Welcome and good Monday afternoon, everybody. So glad to have you aboard. Welcome to the drama-free true crime destination known as Bethea'S Byte Reloaded. I'm Ernest Bethea, the last outlaw. Again, so good to have you on board. And we've got a lot to get through today. So, being that it's lunchtime, I suggest you grab yourself a bite to eat, get yourself a little something to drink, get all that taken care of, because right about now it is time for my opening statement. Okay, another life stolen, another headline soaked in sorrow, another warning ignored. A mother in Bakersfield, California, allegedly pampering herself at a spa, left her two children in a sweltering car. One child is gone forever. In the words of DJ Khaled, another one. But this isn't just a chart-topping catchphrase. It's the funeral march of a preventable loss. How many public service announcements must be aired? How many funerals must be held? How many tears must be shed before society internalizes the simple truth? A car can become a casket, not over hours, minutes. This isn't about vilifying one person, in this case, 20-year-old Maya Hernandez. It's about facing the epidemic of indifference, where comfort, distraction, or carelessness eclipse the most sacred duty as parents, protecting our children. Ladies and gentlemen, this opening statement isn't about just this case. It's about every child that didn't make it out. Every parent who forgot, and every system that failed to educate, warn, and act. The name of Sebastian Gardner rang in our hearts last time. Today, it's Emilio Gutierrez. Tomorrow, who knows? It's up to us to stop this cycle. And we've got to do it with no gimmicks, no drama, and no BS. Ladies and gentlemen, welcome to Bethea'S Byte Reloaded. Thank you for joining me here. And like I said, we've got a lot to get to. So let me go through this thing real quick and do a little house cleaning. If you like what you're seeing and hearing thus far, I'm asking you to drop me a like, share, subscribe, and a comment to support the channel. This is the free way to do it. If you'd like to support me monetarily, I would love to get that too, because this helps to keep it going, and I don't have to suffer long gaps in between. You can hit me up at PayPal EKB316, or Cash App $EKB316. Nothing is obligated, but it's always appreciated. If you're on the chat and you would like to join me and bounce some ideas and opinions off of me, there's a link I pinned in the chat that'll bring you right here. I would love to have you join me. All right. Also, if you want to get a hold of me all over social media, you can hit me up on Facebook at Bethea'S Byte Reloaded, on X at EKB316, all caps, on YouTube at Bethea'S Byte Reloaded, on Instagram at EKB316, all lowercase, on TikTok, as long as we got it, at King of Hearts 316 2021, or you can email me. The address is kingofhearts316_09 at outlook.com. All right, let's get it going. Let's get it going. Let's get this thing going. First story, we have a pediatrician who murdered her daughter and staged a drowning on a Florida trip. Let's get that underway. An Oklahoma pediatrician, oh, by the way, this is out of El Portal, Florida. An Oklahoma pediatrician is facing murder charges in Florida after police say she killed her 4-year-old daughter, then staged the scene to look like a drowning. Dr. Naya Gupta was arrested in Oklahoma County, Florida, Oklahoma. Hold up. I am fumbling and fumbling and fumbling. Let me try this one more time. Dr. Naya Gupta was arrested in Oklahoma County, Oklahoma on July 1st and will be extradited to Miami-Dade County, Florida to face charges. In a news release, investigators said El Portal police were dispatched to a 911 call at approximately 4:30 a.m. on June 27th, where a child was reported to be drowning in a pool at a short-term rental home. First responders pulled the child from the water, identified as Gupta's 4-year-old daughter, Anna Talafi, and took her to a hospital where she was pronounced dead. Investigators determined that Gupta had traveled with her daughter from Oklahoma City and the two were staying at the rental. According to an arrest warrant reviewed by Court TV, Gupta initially told officers that Talafi accidentally drowned when she slipped out of bed during the night, but an autopsy performed by the Miami-Dade Medical Examiner's Office revealed no water in the child's lungs or stomach. The autopsy determined that Talafi's death was consistent with asphyxiation by smothering, noting signs of trauma inside her mouth. Investigators alleged that Gupta had attempted to stage the drowning. Gupta was involved in a custody battle with her ex-husband at the time, according to investigators. When officers spoke to the child's father, he said he didn't know that Talafi had been taken out of state. We are disappointed that the Miami-Dade Sheriff's Office succumbed to pressure and rushed to judgment, Gupta's attorney, Richard Cooper, said in a statement to WPLG. As a result, a grieving mother who just lost her daughter is in jail. We look forward to a full investigation which will uncover the truth of the matter. In a statement to KOCO, Oklahoma University Health said Dr. Naya Gupta was suspended from patient care, given notice of her termination, and was no longer seeing patients at the health system as of May 30th, 2025. She has also been given notice of termination by the university. All I can wonder is what may have that little girl done? Excuse me one second. What could that little girl have done to warrant her mother smothering her to death? There we go. What could she have done? And then on top of it, that lie? I mean, let me look at that lie again. Slipped out of bed and accidentally drowned. I mean, was she sleeping outside by the pool or whatever? Number one, and number two, if that were the case, why wasn't there any water in her system? I swear these cases get crazier and crazier and crazier If it ain't a child killing their parent, it's a parent killing their child. What's now? Oh, speaking of which, we've got a kid right now who's about to face trial for, now get this, folks, beheading his father, then posting the grisly footage to YouTube. And if you're probably thinking in your head, he did what? Yeah, I'll break it all down for you in this article, courtesy of People Magazine. This is our defendant, Justin Moan. And as you can see from the subheading, he's facing multiple charges, including first-degree murder and abuse of a corpse in connection with the 2024 death of 68-year-old Michael F. Moan. Here's the story in its entirety. The trial for a Pennsylvania man accused of decapitating his father and displaying the severed head on a video posted on YouTube began on Monday, July 7. 33-year-old Justin Moan is facing charges of first-degree murder, abuse of a corpse, possession of an instrument of crime, and terrorism-related charges in connection with the 2024 death of 68-year-old Michael F. Moan. According to a probable cause affidavit viewed by People Magazine, officers found the decapitated remains of Michael in the downstairs bathroom of the family's Levittown home on January 30th, 2024. Officers found a machete in the bathtub and a large kitchen knife. Michael's head was found in a plastic bag. Hold on, I gotta stop there, and I've got to put up a trigger warning for this, because even this is turning my stomach into. Hang on, guys. There you go. I should have gave you the warning that this was gonna be kind of graphic at the beginning, so that one's on me. I apologize. Here's another here's the trigger warning for everyone in chat. Alright, let me start this back. The trial started on Monday, July 7th. Justin Moan is facing charges of first-degree murder, abuse of a corpse, possession of an instrument of crime, and terrorism-related charges in the 2024 death of 68-year-old Michael F. Moan. According to a probable cause affidavit viewed by People Magazine, officers found the decapitated remains of Michael in the downstairs bathroom of the family's Levittown home on January 30th, 2024. Officers found a machete in the bathtub and a large kitchen knife. Michael's head was found in a plastic bag inside a cooking pot in a first-floor bedroom near the bathroom, according to the affidavit. Investigators also discovered a video entitled "Moan's Militia Call to Arms for American Patriots," posted to Moan's page on YouTube. The 14-minute video allegedly showed Moan picking up the decapitated head of his father, Michael Moan, identifying him by name and as his father, stating, quote, "He is now in hell for eternity," end quote. And that's according to the affidavit. The video also allegedly ordered all militia and patriots across the United States to kill all federal employees, quote unquote. And that's according to the Bucks County District Attorney's Office in a press release. He also allegedly listed several targets for capture and public execution, including specific federal officials and a U.S. District Court judge. Moan's father worked with the Army Corps of Engineers, prosecutors had said. An autopsy determined that Michael was shot in the head before he was decapitated. That's according to the prosecutors. After the suspected killing, Moan, who was armed with a handgun, fled the scene in his father's 2009 Toyota Corolla, according to authorities. He was eventually captured after investigators tracked him via his cell phone to the National Guard Training Center in Fort Indiantown Gap. Prosecutors alleged that Moan was there to try and convince the National Guard to rally against the federal government. Investigators also found a USB device that contained several pictures of federal buildings, along with instructions that appeared to show the steps needed to make an explosive device, according to prosecutors. First off, I think this guy is a couple of aces short of a full deck. Second, I know you're not in agreement with the government. I get that. I feel the same way. But look at my face when I say this. I am not going to go through this whole doggone process where I have to kill somebody to make a point. I am not going to go through this process to make terroristic threats in order to get my point across. We all have our opinions. Some of us agree, some of us disagree. But we all have our opinions about the government. We don't have to take it as far as this young man did. This thing is already going to trial. It would not surprise me enough if he was found guilty of these charges. And the sentence, if they have the death penalty there, and I'm thinking about in other cases I say this, it would not surprise me if they sentenced Justin Moan to death by firing squad. That would not surprise me. Next up, an ex-boyfriend was arrested days after missing teenager Marissa DiNapoli was found slain in California. Just days after. This is Marissa here. Here's what we know. Police found the body of an 18-year-old woman reported missing in California, and her ex-boyfriend, who was suspected of murder, was just arrested in connection with her death. Marissa DiNapoli was last heard from by her family through text on June 28th at 9:16 p.m. She told family members that she was staying with a friend for the evening, but when her family didn't hear from her the next day, they reported her missing, according to the Morgan Hill Police Department. After searching, police found a body at Lake Anderson on July 2nd and confirmed it was DiNapoli's on July 3rd. DiNapoli was last seen leaving a home with this man you're seeing on your screen right now, Martin Mendoza, her ex-boyfriend, on January 29th at 9:45 a.m. Police initially suspected him as a person of interest and arrested him Sunday on a murder charge, according to a statement by the Morgan Hill police. They arrested him at the California-Mexico border crossing while he was trying to re-enter the United States. While Mendoza's arrest may bring a measure of relief, it does not ease the heartbreak we all continue to feel, Morgan Hill police wrote in their statement. Marissa was a radiant, compassionate young woman with a future full of promise. DiNapoli's families have said in their own statement that they appreciate all the love and support they have received on her behalf. The loss of our beloved Melissa deeply saddens us, and at this time, our family kindly asks for privacy as we grieve and navigate this difficult journey, the Napoli's family wrote. In honor of Marissa's memory, we kindly ask that no GoFundMe accounts or donation pages be created. If you wish to show support, please do so through your prayers, kind words, and cherished memories. DiNapoli's former teacher at Opportunity Youth Academy, Tara Guerrero, had been helping family and friends in the search after she was reported missing, according to NBC Bay Area. Every student in my class touches my heart, but her especially, Guerrero said to the outlet. She had the brightest smile that would light up every room. She was friends and friendly with everyone who came into our classroom. She was just one of those kids that leaves a mark on your heart, and I have a broken heart right now. It is rough whenever when you lose someone you've been so totally attached to, whether it's a friend, a family member, or a loved one. But to lose them in such a vicious manner, it's something that it's something even I can't comprehend. But with this article, I also leave a public service announcement that goes with it. If you or someone you love are experiencing domestic violence, you are urged to call the National Domestic Violence Hotline at 1-800-799-SAFE, 1-800-799-7233, or go to thehotline.org. All calls are toll-free and confidential, and it's available 24 hours a day, 7 days a week, in more than 170 languages. You do not have to be another statistic. Call the National Domestic Violence Hotline and get the help you need. That number again, 1-800-799-SAFE, 1-800-799-7233, or go to www.thehotline.org. All right. Next up, a Karen Reed update. We have an investigator in the Karen Reed case transferred out of the DA's office. Alright, we're out of Boston. One of the lead investigators who built the case against Karen Reed has been removed from the Norfolk County District Attorney's Office and reassigned. Massachusetts State Police Sergeant Yuri Bukvik, if I'm pronouncing it right. Bukvik testified alongside his partner, former trooper Michael Proctor, in Reed's first trial. During her retrial, Bukvik testified without Proctor and faced a contentious cross-examination about his and his partner's behavior during the investigation. This is the gentleman right here. Reed, who stood trial twice on charges that she murdered her boyfriend, Boston police officer John O'Keefe, was acquitted of the most serious charges in June. While Reed's first trial ended in a mistrial when the jury could not reach a unanimous verdict, the second jury found that while Reed was guilty of operating a motor vehicle under the influence of alcohol, they found her not guilty of all other charges. Proctor was suspended from duty during Reed's first trial after admitting under oath that he had sent crude and inappropriate text messages about the defendant to colleagues. After 3 appearances at a police trial over 7 months, Proctor was terminated from the Massachusetts State Police. Buckenick had served as Proctor's supervisor and during the investigation into O'Keefe's death. During Reed's retrial, Buckenick testified that he lost 5 vacation days as a penalty following the internal investigation that led to Proctor's eventual termination. While Reed's attorney, Alan Jackson, questioned Buckenick about how evidence was collected and why detectives focused on Reed, Buckenick maintained that the investigation had been conducted with honor and integrity. A spokesperson for the Massachusetts State Police told Court TV that Buckenick was reassigned, effective Sunday, July 6th, from his previous position at the Norfolk County District Attorney's Office. In his new position at the Division of Standards and Training, Buckenick will perform a variety of administrative functions in support of the division's daily operations. A personnel order shared with Court TV identifies the move as a temporary duty assignment that extends through October 4th. My opinion? If that investigation was done, as he said, with honor and integrity, it's highly possible that Karen Reed would have been found guilty of her boyfriend's murder and thus doing time behind bars. And then on top of it, Michael Proctor would likely still have been terminated from the Massachusetts State Police, all because of his inappropriate behavior. I'd say that in a small sense that's justice. Next up, a former Indiana sheriff's wife, Misty Knoll, is apologizing for stealing public funds. That I'm pretty sure is her apology before being sentenced on those crimes. Yeah. The wife of a former Indiana sheriff left the courtroom in handcuffs after pleading guilty to stealing public funds to support her family's extravagant lifestyle. There we go. Misty Knoll pleaded guilty to 5 counts of theft and tax evasion in a deal with Indiana prosecutors. She was sentenced to more than a year in prison and nearly $700,000 in restitution to the entities from which she stole for purchases including jewelry, meals, and clothing. Misty is the estranged wife of former Clark County Sheriff Jamie Knoll. The career lawman appeared on A&E's 60 Days In before facing allegations he stole millions of dollars from the volunteer firefighter and emergency medical services he oversaw. Jamie pleaded guilty to 27 charges of corruption, theft, official misconduct, obstruction of justice, and tax evasion in 2024. He's currently serving 12 years in prison. Judge Larry Medlock approved Misty's plea deal at the July 3rd hearing. He sentenced her to 6 years in state custody, 1.5 years in prison, or likely because she'll get credit for time served, followed by 4.5 years on probation. She has filed for divorce from her husband. Misty offered a tearful apology to the community and her children at her sentencing. Her adult daughters, Casey Knoll, pleaded guilty in February to theft and tax evasion, according to a report from WDRB. How I feel about the events that's led me here today, I have a great amount of remorse for my ignorance that not only led me to here, but led my children here as well, Misty said. And I have a great deal of love for not only the people in my family and my community, but I have a lot of respect for everyone sitting in this courtroom. So I apologize. Misty supporters, including daughter Casey, filled the courtroom audience, along with people affected by the theft of resources from the Utica Township Volunteer Firefighters Association and New Chapel EMS. Jamie Knoll oversaw the operations of both entities during part of his tenure as Clark County Sheriff. Special Judge Larry Medlock, who presided over both cases, called the Knowles plundering of life-saving resources and assault on our democracy. He told Misty, "You turned trusting citizens into victims of your greed." Nevertheless, the judge said he would not bow to public pressure for a harsher sentence for Misty. He also called out Misty for leading her children into crimes of dishonesty. "It's not a matter of revenge. It's a matter of justice. I trust that the state of Indiana has done what they believe to be appropriate in this circumstance. I sincerely hope from this day forward they truly become the most important things to you, and that you can become a woman and a mother of integrity who is dedicated to the care of others more than to your own self-indulgence." And I stand with that judge on that statement. I mean, if you're supposed to be in the care, if you're supposed to be in the care of a community, in charge of volunteer firefighters, in charge of EMS services, and then you're taking money away from them like that, how do you expect the community to trust you? While Misty may have filed for a divorce from her husband Jamie, he's still doing the 10 years behind bars for his part in this whole corruption. Maybe some people will say that Misty Knoll got off easy. She got off light. But the bottom line is, she still has to pay that money back. All $700,000 worth. Something to think about, right? Next up, we have a trial that's underway already, the Bloody Suspect Murder Trial, State of Iowa versus Nathaniel Bethea'S McGivney. Here's all the details that led to this trial. We're out of Calhoun County, Iowa. An Iowa man is facing life in prison without the possibility of parole after being convicted in the killing of a 17-year-old that left the community in shock. In their opening statement, prosecutors said Nathaniel Bethea'S McGivney, age 22, murdered Michelle Luna Jackson by cutting her throat and stabbing her on September 22, 2024 in Farhamville. Jackson was reported missing that day. When her family went looking for her, they stumbled upon Bethea'S McGivney, who was covered in blood and had her belongings, including her green scooter, according to prosecutors. Investigators found Jackson's body the next day and arrested Bethea'S McGivney. The defendant was charged with first-degree murder and abuse of a corpse. At trial, the defense conceded that he killed Jackson, but said his actions didn't rise to first-degree premeditated murder, arguing for a lesser conviction of second-degree murder. Bethea'S McGivney waived his right to a jury trial, opting instead for a bench trial. Judge Derek Johnson ultimately agreed with prosecutors and convicted the defendant of first-degree murder and abuse of a corpse. The sentencing is scheduled for August 15th. So honestly, there shouldn't have even been a trial. He was gonna go ahead and say, yes, I'm guilty, and no need to wait. Then again, it's probably according to the judge's schedule, August 15th for the sentencing date. This guy's got very slim chance of going to prison for a good long time. Alright. Next, a friend of the Alexander brothers has been cleared in a sexual assault case. Cleared. Alright, Miami. Prosecutors have dropped charges against a friend of the Alexander brothers who was accused of helping them rape a woman nearly a decade ago. In December, Ohad Fisherman surrendered at the Miami-Dade County Courthouse on a charge of sexual battery by multiple perpetrators. Investigators claim Fishman, who you see on the right-hand side of your screen, helped twins Alon and Orrin Alexander rape a woman on December 31st, 2016, as reported by the Associated Press. Alon Alexander allegedly invited the woman to his Miami Beach apartment for a New Year's Eve barbecue, sending her photos with people already in attendance. When she arrived, however, the only people present were the twins, Fisherman, and two maids. The woman told police that the Alexanders and Fisherman took her into a bedroom where Fisherman held her down while the twins took turns raping her. She said she was told not to tell anyone. That alleged assault is one of 3 allegations the Alexander twins face in Florida State Court. Fisherman's trial was expected to begin on last Tuesday. However, prosecutors announced they were dropping the case after a final hearing. In a statement obtained by Court TV, State Attorney Catherine Fernandez Rundle said in part of the evidence learned by the state subsequent to the filing of this case was a Facebook post which included a video purportedly placing Fisherman on a boat cruising on the water in Miami Beach at sunset on New Year's Eve 2016, very close in time to the sexual battery incident. Also, according to Facebook records, the video was posted around 9 p.m. that same night. After the prosecution disclosed this evidence to the defense, on July 2nd, 2025, Ohad Fisherman filed a notice of alibi with the court. In his filing, Fisherman claims that at the time of M.W.'s sexual battery, he was on a boat in the water somewhere along the Intracoastal Waterway. The defendant's presence at the scene of the crime is an essential element of proof, and this video evidence casts doubt on that proof. Given the prosecution's inability to conclusively disprove the alibi, we are determined in good faith that we could not prove the case against Ohad Fisherman beyond and to the exclusion of all reasonable doubt, which is required by law. Rundle said the cases against Orrin and Olon remain pending and unaffected by the dismissal of the charge against Fisherman. Well, that's how it goes, folks. It's the prosecution's job to prove a case beyond beyond all and the exclusion of all reasonable doubt. If if the evidence is there, they can do it. If the evidence is not there, it's impossible to do. So that's how Fisherman is clear. But the Alexander brothers, like the article said, that's still pending. So I'm still waiting to see what comes next. Another trial going on right now is the attempted honor killing trial. Washington against Zara Ali and her husband. Yep. Okay, nice catch. Alright. This is out of Thurston County, Washington. A mother and a father in Washington state are accused of trying to kill their teenage daughter. Ihsan Ali, on the right, and his wife Zara Ali are facing several charges, including attempted murder, following the incident at Timberline High School on October 18, 2024. According to court documents, Ihsan had recently threatened his daughter with an honor killing. The girl's parents found her on the school campus as she walked with her 16-year-old boyfriend to a bus stop. Witnesses say Ihsan punched the boyfriend and placed his daughter in a chokehold until she lost consciousness. Witnesses captured cell phone video of multiple bystanders punching Ihsan and pulling him off his daughter. Court documents reveal that her mother, Zara, had been banned from the school campus about a month prior for allegedly trying to grab the girl's boyfriend. Both parents remain in custody, and the trial has already started. In fact, you can see all the different videos regarding this case. Defense attorneys saying Ihsan and Zara Ali thought their daughter ran away. A bus driver describing the chaotic scene, including Ihsan choking his daughter, and then the bus camera footage of Ihsan Ali allegedly choking his daughter. Wow. And they want to call that an attempted honor killing. What honor is that? What honor is there in killing your child? I'll even flip the script around now because I made this argument before. What honor is there in a child killing their parents? What in the world? What is this world coming to? Next, in another Karen Reed update, blogger Aidan Kearney pleads not guilty to new witness intimidation charges. Aidan Kearney, I think YouTubers will recognize him under the name Turtle Boy. Controversial blogger Aidan Turtleboy Kearney pleaded not guilty to 2 new counts of witness intimidation during an arraignment in Massachusetts court on last Tuesday. The charges stem from an alleged incident outside Colin and Chris Albert's pizza shop in May 2025 during Karen Reed's murder retrial. The parties also addressed several outstanding motions related to another witness intimidation case filed against the blogger in 2023. Defense attorneys Tim Brattle and Mark Betterow renewed their request to release impounded documents related to the case. The fact things are embarrassing or scandalous or cause negative light to be cast on public officials is not a reason to impound documents. It's more a reason to release them, Brattle said. The defense team specifically requested the release of messages between a former trooper, Michael Proctor, and a civilian witness, arguing they were of public interest. Proctor has been on a press tour, vigorously defending his investigative conduct. The impounded messages, the public is entitled to see them, Bethea'S said. Prosecutor Robert Cosgrove provided approximately 5,000 to 6,000 pages of discovery to the defense team, but requested a protective order for the documents. The judge allowed the prosecutor's motion without prejudice and will issue a ruling in 2 weeks after reviewing additional submissions. The defense also filed a motion to dismiss Special Prosecutor Kenneth Mello, claiming he's an essential witness in the case. We're led to believe Mr. Mello will not voluntarily withdraw. We believe he's going to be a defense witness, Bethea'S said. So the next court date is scheduled for August 5th. And we're all going to find out on that day exactly what lies ahead for Turtle Boy. Next up, we were under a verdict watch last week, and we have a verdict for the Crystal Rogers murder. Brooks Houck and Joseph Lawson were both found guilty in that case. Bowling Green, Kentucky. 2 men have been found guilty of all charges in the disappearance and murder of Crystal Rogers. Brooks Houck stood trial alongside his former employee's son Joseph Lawson on charges of complicity to commit murder and complicity to tampering with physical evidence. Rogers was dating Houck when she disappeared on July 3, 2015, and was last seen at his family farm. During closing arguments, prosecutor Shane Young told jurors while he couldn't say who killed Rogers, he knew who was involved, referring to Houck and Joseph and Stephen Lawson. The prosecution argued Houck lured Rogers to his family farm on the evening of July 3, 2015, claiming they were going on a surprise date. Young told the jury that a surprise date turned into a surprise ending for Crystal. Houck's attorney described the state's case as garbage in their closing argument. Lawson's attorney highlighted that Lawson's name was barely mentioned during the trial, noting that prosecutors focused more on his father Stephen, who had already been convicted, as well as Houck's mother Rosemary and brother Nick. Both defense attorneys argued there was no evidence connecting either man to Rogers' murder. The prosecution case relied on circumstantial evidence. They hoped jurors would use common sense to recognize that Houck repeatedly lied about his whereabouts when Crystal disappeared, and that Houck and the Lawsons were communicating the night she vanished and into the early hours of July 4th. The jury recommended a sentence of 25 years for Joseph and life for Houck. A formal sentencing is scheduled for August 21st. I would have to gather that regardless of those sentences, those guys are not going to survive. And on top of that, they were able to get this conviction without ever finding Crystal's body. So yes, that has happened before. So when that day comes for the sentencing, I'll be sure to bring it to you one way or the other. Next, speaking of sentencing, Sean Diddy Combs has an October sentencing date. For his federal convictions. Let's go back to New York City. Following a brief hearing last Tuesday afternoon, a federal judge set the sentencing for Sean Diddy Combs for October 3rd, where he faces years behind bars. Combs remained jailed after he was convicted of 2 counts of transportation to engage in prostitution, following a months-long federal trial. The former music mogul was acquitted of the more serious charges of racketeering and human trafficking he had faced. The hearing had initially been scheduled because Combs' attorneys had filed a request for an expedited sentencing. However, in the minutes before the hearing, the defense and prosecution submitted a joint letter to Judge Aaron Subramanian, stating they would adhere to his initial proposed sentencing date of October 3rd. The letter also included a timeline for completing the pre-sentence investigation report and deadlines for responses and sentencing memoranda. Judge Subramanian endorsed the proposed dates and signed in a signed order immediately following the brief audio-only remote hearing. Curiously, defense co-counsel Xavier Donaldson was in the courthouse for the conference and walked out after it ended. He did not answer reporters' questions about why he attended in person. While Combs' defense had previously offered to waive the customary pre-sentence investigation, Judge Subramanian indicated he would be relying on it to help through the great divide between the parties' views, even as to the basic question as to how the sentencing guidelines apply here. Combs' defense has argued that the client faces a range of 21 to 27 months in prison, while federal prosecutors argue he should face between 51 and 63. No matter what the sentence is, Diddy should remember the old phrase, and my wife repeats it all the time. Let me shout out my wife, Lady Outlaw, Crystal Bethea. She always says it. Don't do the crime if you can't do the time or pay the fine. And if they sentence Diddy under the Mann Act, he'll be in there for at the very least, 10 years. Next up, I'm trying to get through this quickly. Judge orders evaluation for Jose Ibarra. Ibarra was convicted of killing Lake and Riley, and now they're ordering an evaluation for him. Okay, the side of Atlanta. A judge has ordered a mental evaluation of the Venezuelan man convicted of killing Georgia nursing student Lake and Riley. A judge in November found Jose Ibarra guilty of murder and other crimes in Riley's February 2024 killing and sentenced him to life in prison without the possibility of parole. Ibarra is seeking a new trial, and his lawyers asked the jury to order a mental evaluation as part of that process. Clark County Superior Court Judge H. Patrick Haggard's order for a mental evaluation was sent to the State Department of Behavioral Health and Developmental Disabilities on last Tuesday, according to a letter filed with the court. Prosecutors said Ibarra encountered Riley while she was running on the University of Georgia campus on February 22nd and killed her during a struggle. 22-year-old Riley was a student at Augusta University College of Nursing, which also has a campus in Athens, about 70 miles east of Atlanta. In a court filing last month, Ibarra's post-conviction attorneys James Luttrell and David Dowds said they believe Ibarra suffers from a congenital deficiency that could make him incapable of preparing a defense and standing trial. Ibarra lacks mental capacity to understand the proceedings, and his attorney wrote that he believes that was the case at the time of the killing and at the time of the trial. The 27-year-old Ibarra has waived his right to a jury trial, meaning it was up to Athens Clark County Superior Court Judge H. Patrick Haggard alone to hear and decide the case. A criminal defendant must personally and intelligently participate in the waiver of the constitutional right to a trial by jury, Luttrell and Dowds wrote, noting that Ibarra's trial attorney did not ask for a competency evaluation. Prosecutor Sheila Rice wrote in a court filing responding to the request that there were no challenges or concerns. Stood without a bar. Let's see. Where was I at? Prosecutor Sheila Ross wrote a court filing responding to the request that there were no challenges or concerns about Ibarra's competency prior to trial and that there is nothing in the trial record that would suggest that the defendant was not competent during his trial. But she wrote that does not oppose the request for a competency evaluation. Judge Haggard, the week before, filed an order asking the Department of Behavioral Health and Developmental Disabilities to evaluate Ibarra with the aid of a Spanish-language interpreter. He requested findings on whether Ibarra was capable of understanding the pre-trial proceedings involving the waiver of his right to a jury trial, as well as the trial itself, and whether he was capable of assisting the attorney in preparing his defense. He also wants to know whether Ibarra understands the post-conviction proceedings and can aid in preparing his defense. Ibarra was convicted November 20th, and his attorneys filed a motion for a new trial on December 2nd under Georgia law. A notice of appeal must be filed within 30 days of a conviction becoming final, which is the date of sentencing or the denial of a motion for a new trial, whichever is later. Therefore, the filing of a motion for a new trial effectively extends the deadline to file an appeal. So, he's been convicted of murdering Laken Riley, and now the defense wants to say he was incapable of presenting his own defense, participating in trial. I doubt that. They even going as far as saying that he was I'm drawing a blank as to what to say next regarding this. We're just gonna have to wait to see what'll become of what becomes of the evaluation. Then I can present my opinion for it then. Next up, a judge is pushing for a federal investigation into the Harmony Montgomery case. You remember Harmony Montgomery, don't you? A little girl who was killed by her stepfather. That was a sad case to cover. In fact, instead of me going to the article, I'm going to bring you the report courtesy of my good friends at Court TV, your front row seat to justice. So what I'm going to do is switch to this. Okay, there's that. Come back here and make sure you all see the copyright disclaimer before I start that video. Alright. We're going to take it to Court TV into this article. Judge pushing for a federal investigation into the Harmony Montgomery case.
Here the child died, but I would direct...
The child didn't just die. The child was killed after the child was given to the person, the state delivered the child to the person who killed him, right? And that was a father.
Harmony Montgomery back in the spotlight this morning now that a former Massachusetts judge has filed a federal complaint requesting an FBI investigation into Harmony's murder. The Honorable Carol Erskine wants investigators to look at New Hampshire's Division of Children, Youth, and Families and find out if workers falsified records relating to Harmony's case. Recently, New Hampshire awarded Harmony's mother, Crystal Sori, $2.5 million to settle her wrongful death lawsuit against the state. Judge Erskine says she feels like that's an attempt to cover up why Harmony was placed with her father, Adam Montgomery, despite information that she wouldn't be safe with him. Now, Adam Montgomery, you may recall, is locked up. He's serving 56 years to life in prison for killing his beautiful daughter. So let's talk about this request for a federal civil rights investigation. Who better to do it than the people I call Harmony's best advocates? So I'm going to welcome in retired juvenile court judge Carol Erskine. Now she also handled the adoption of Harmony's little brother Jameson, and we have Jameson's adoptive parents Blair and Jonathan Miller with us as well. They've been outstanding advocates for Harmony too. Good morning to you all. Judge, let's start with you, please. Why do you think that award of money is part of a cover-up?
Well, good morning, first of all, Julie, thanks for having me on. The reason that I say it's part of a cover-up is because $2.5 million is basically what it costs to keep the secrets of what happened to Harmony hidden. I mean, the true fact is that Harmony's case with the Department of Children, Youth, and Families has been covered up for quite some time. And the settlement in the civil suit is an agreement that for $2.5 million, the state has no liability and no wrongdoing. So for me, in $2.5 million is the price of silence. And I just wasn't going to let that happen, which is why I'm pursuing a federal investigation under the color of law, which allows for criminal prosecution.
And Judge, your point of view is that Harmony's civil rights very well may have been violated by these DCF workers when they were coming to the home to check on her. Would you tell us a little more, please?
Right. I make the argument that her due process rights were violated in two ways. Procedural due process, which was what happened on July 29, 2019, the day that Harmony could have lived had the investigation been done properly. It was a requirement by law that there be an immediate investigation when there was an allegation of a dangerous physical assault, giving her a black eye by her father. But even though the governor's report states that Harmony was seen that day and that there was, by law, they complied by notifying the police, what happened actually was that she wasn't evaluated, that Adam Montgomery received a call saying they were coming to evaluate her. He grabbed Harmony, he took her out of the house, and he fled with her so that she couldn't be seen. And then the police were notified that Harmony was seen and that there were no injuries. That was a severe violation of her due process right to a fair investigation. And it was actually the day she could have lived had it been done right. But I make the allegation that it may have been deliberate, that he was warned, and therefore she wasn't seen. She wasn't actually seen until sometime in August when the bruising was gone.
It's so heartbreaking, Judge, as you know. Thank you for all of that. Blair and Jonathan, I want to turn to you both now. You have been advocating for Harmony since, gosh, by the time, my gosh, we're going back years, when you first learned that she was missing. So this has just been, a torturous period of time for you all, till you found out about her death, the prosecution, and now I know that it's very important to you both to continue advocating for her. So I'd like to ask why, where that drive comes from, and I would love for you both to answer. Whomever would like to start first, go right ahead, please.
Julie, good morning. I'll start. So for us, it's so important because Harmony mattered. She was a child. She was more than just a paycheck. She mattered to our son, Jameson. And if we don't stop this and protect the most vulnerable children in America that are at the most risk, this is going to continue to happen. It's going to continue to be more of Harmony's stories, and we don't want that. This should have never happened, and we don't want it to happen to another child.
I think we constantly are thinking, what would Jameson want us to do? And hopefully we're doing that because, yes, he's 8 years old today, but when he is 15, 16, 17, 18, and through his life, he's going to be asking questions. What did my dads do to protect my sister? But more importantly, at this point, what's being done to make sure this doesn't happen again? And the fact of the matter is nothing.
And I know that angers you both, and I applaud you for your advocacy and your interest and your passion for this. I want to share with anybody who may not know, you both would have been willing to take Harmony. So I want to go back to when she was alive. You two, I say you guys are like angels, and I really mean that. And if it weren't for you, who knows what would be happening with Jameson right now. But when you were adopting him, I know that you were willing to take Harmony too, but legally she wasn't available for an adoption because Adam Montgomery had asserted his parental rights and he had custody. So that being said, when we think about Jameson and what a precious little angel he is, I mean, his birthday today, how much does he know, Jonathan and Blair? How much do you share with him? Because obviously this is very adult and very upsetting, but I know you both do a tremendous job being transparent as you can with your beautiful kids.
So we have a team that helps us with Jameson, or professionals, including his doctor, what's age appropriate. And for him, he knows that someone didn't take care of Harmony, so she passed away. But we always try to honor her on her birthday month. For instance, this month, for this year, for her birthday, he said, what can we do to remember her? And we talked about it, and her glasses are very special to him. So we collected glasses. We collected over thousands of pairs of glasses that we're going to donate to children that actually aren't able to pay for prescription eyewear.
And people sent this to us, and so we're so thankful that. But Julie, this pops up. His sister will pop up in ways we never really expect. And while we try to honor her, it's not unusual for a teacher to call us and say, today Jameson drew a picture of Harmony, or today he said, my sister is no longer alive. And he's very, very matter of fact, and he doesn't really sugarcoat some of these things. But yes, we try to have age-appropriate conversations with him, but he knows that's she's no longer with us. But we try to remember it as best we can.
He's on the swim team, and he told his coach, she asked if he had a sister. He said, I have two brothers. He goes, well, I do have a sister, but she's in heaven watching us right now. And he actually got the coach's award for the swim team this summer, so we're really proud of him.
Oh, congratulations and happy birthday to adorable Jameson. And it's wonderful that he's able to live such a beautiful life with your family. Thank goodness for that. And I know you all keep us posted as developments come. For anyone looking for more information, the justicefile.com, is that right, Judge Erskine? The Justice File, is that the website you have launched?
Yes, it's called thejusticefile.com. There's a 3-part series talking about how her due process rights were violated and how for 3 months they never allowed Harmony to see a doctor or a specialist or be in school, how she was isolated for 3 months, and how DCYF chose not to provide any protection for her whatsoever. So that's the basis of my filing. Met with the FBI last Tuesday, so we'll see what happens.
I know you'll keep us posted. Thank you all for the great advocacy for Harmony. Our courties love Harmony and love seeing how Jameson is able to live his best life. So Judge, Blair, Jonathan, thank you so much for this conversation. Also, if you want more information, thejusticefile.com, you can read about this. And please, pick up Judge Erskine's book, A Cruel Injustice. Proceeds go to the Dave Thomas Adoption Foundation.
It's sad. It's a sad thing when A child is brutally murdered, and hardly anyone is standing up for justice for said child. It's a good thing there's that judge and the parents of Harmony's little brother are continuing to advocate for her. I salute them all for doing what they're doing, and I stand in agreement to have a federal investigation done, because there's a lot that hasn't been, there's a lot that hasn't been done, a lot hasn't been said, and to award that kind of that amount of money, I believe there's a cover up somewhere. Just have to wait and see what comes next. And one of the big stories we had earlier this week, a Georgia teen has been arrested for killing her mother and her stepdad after 911 call. And again, we're gonna go right to Court TV for this story too. Stand by.
On February 20th, on the morning of February 20th, 2025, deputies with the Carroll County Sheriff's Office responded to a tragic scene at 1531 Carrollton Tyus Road. They discovered the bodies of James Brock, 45, and Kristen Brock, 41, both deceased from apparent gunshot wounds. From the very moment the 911 call was received, a relentless investigation began, one that would span months, consume thousands of man hours, and require the full weight of the local and federal law enforcement agency partnerships. Today, we can confirm that an arrest has been made in the case. Kristen Brock's 17-year-old daughter, Sarah Grace Patrick, has been taken into custody and charged with 2 counts of murder and 2 counts of aggravated assault in connection with the deaths of her mother and her stepfather.
A lot of people talking about this case and talking about this defendant, 17 years old, accused of murdering her mother and her stepfather. And you take a look at that mugshot. Does it look like your typical double murder suspect? No, it doesn't. I mean, she looks young, she's got freckles, but this is a serious case, and it's still a very active investigation. And here to shed more light on the case is Carroll County Sheriff's Office spokesperson Ashley Hulsey from Georgia. Ashley, thank you so much for joining us. The timing of this, was this a difficult case to solve? Why 5 months?
Well, as you know, Vinny, every good investigation takes time. Our main goal is to follow where the evidence leads and make sure that we make the arrest of those that are responsible. And as you know, and I stated in my press conference yesterday, unlike CSI and other things that we watch on television, evidence is not processed overnight. As much as we would like for that to happen, that is not the case. So it has taken months to be able to send all of these things to different laboratories throughout the country to be able to get some of this forensic evidence back that, of course, led us to the arrest yesterday of the 17-year-old Sarah Grace Patrick.
Okay, and you talk about forensic evidence. Is that the basis of this? Are there any admissions, any eyewitnesses? What is the nature of the evidence against this 17-year-old?
So I think, you know, in the beginning when we responded to the scene, you know, there was no signs of forced entry. There didn't appear to be a robbery. We had 2 victims that had been shot to death in the home that had a 17-year-old and a 5-year-old in it at the time. And, you know, she said she didn't hear any of the gunshots go off. That kind of makes you wonder and tilt your head a little bit. But of course, we had to collect evidence, as you know, and throughout this process, as I said yesterday, we have processed digital evidence, forensic evidence, DNA evidence, everything that we can to try to make a case and hold the right person accountable.
So would it be accurate that she was a person of interest right out of the box?
I would say that everybody was pretty much a suspect right out of the box. But as well as I do, when you have a homicide of that nature, you always want to work your way from the inside out. Carroll County is a rural community for the most part, and we don't have stranger on stranger crime a lot.
Is there a belief that there may be more people involved in this?
We believe there absolutely positively could be other individuals involved. And we have been speaking with Sarah over the past couple of days and hoping to shed more light on that aspect of this crime.
Okay, so that's interesting. So the defendant is speaking. The defendant is cooperating?
She has been cooperative. Her family has been cooperative. Like I said, she's been in custody since yesterday, so I have not gotten a lot of updates since then. But prior to her being arrested, she had been cooperative in speaking with investigators.
Has she revealed a motive?
We're still working towards that. We're still gathering evidence. Very active, very fluid. Even though we've made an arrest, there's still a lot of work to be done.
Without revealing the motive, do you have an idea as to why this happened? I know you can't reveal a lot in an active investigation, but are you working under the knowledge that you believe you know why this happened?
We hope to know why this happened. That's what we're working towards. I know there's a lot of conspiracy theories and different things that have been shared all over every social media platform since yesterday, and we're just trying to get down to the root of it so that hopefully one day we can share that with the public as well.
And how's the 5-year-old doing?
Based off of, again, social media things that I've seen posted from the family members, they're taking excellent care of her. I think she misses her mom and dad very much. And, what do you do with a small child like that who found them that morning and was the one that had to witness that? So I'm sure she has a long road of recovery ahead of her, and we pray for her and her family every day.
Is there any surveillance video that's been useful in this investigation?
Not that I'm aware of, no.
And I know, or I've heard, that the defendant spoke at the funeral.
That is correct.
Was there anything significant that she said that helped investigators?
When you're investigating a crime, everything, we watch everything. As you know, I'm sure one of our main goals in an investigation is to look at every aspect. So, of course, we had investigators that attended the funeral because sometimes you will have things that happen, unfortunately, that might lead you in the direction of a suspect or give you pause. She seemed to be upset about her parents being murdered, but I was not there in person, so I don't know if there were actual tears when that happened. And she also said, I'm sorry at the end of it. She could have been apologizing for being upset, or it could have had a deeper meaning. We may never know.
And how about the rest of the family? What has their reaction been to this arrest? Has it made them more cooperative, less cooperative? How is that sort of playing out?
I have not spoken to any of the family personally, but talking with the investigators, everybody's been cooperative. Everyone that they have spoken to thus far has been very cooperative. There's a lot of TikToks going around with different family members who have spoken out today and, said that they, are really upset by what they have found out, that they kind of suspected it along the way. So that's really sad when you have a family member that could have possibly done this to a loved one.
And as to the charges, what are the specific charges and what sort of sentence is she looking at on the high end right now? And do you suspect there's an opportunity that there could be some sort of negotiation at some point?
So I really couldn't speak to that. That would be something the district attorney would have to answer. The investigators have been meeting with the district attorney on this case throughout this process. So that would be a question for them. But at this moment, the Carroll County Sheriff's Office has charged her with two counts of murder and 2 counts of aggravated assault. And I would suspect that more counts would follow in the indictment to come.
Ashley Halsey, Carroll County Sheriff's Office, appreciate your time. Let me just ask you this. Is there anything that I didn't ask you that you think the public should know and that is important about this case?
Because it is still an open active case, we do believe that there are individuals out there that probably have some information. And I would say this, now that this has been public, that Sarah has been arrested, there could be something in your mind that a conversation was had that now means something that maybe didn't mean something 5 months ago. So we would encourage those people to come forward and contact the sheriff's office, even if they think it's insignificant. It actually could be a big deal. So, we urge those people to reach out so we can continue to give this family the closure that they deserve.
Ashley Halsey, thank you so much. Appreciate your time. I know you're busy. We thank you.
Thank you so much. Thank you. All right. Bye-bye.
Let's bring back in our think tank, Randy Kessler, Meg Strickler, Josh Schiffer, all licensed to practice right here in the great state of Georgia. What are your thoughts here? How is this going to play out?
Guaranteed.
How important is the why of it? To me, I feel like the why of it could be connected to another potential suspect.
Guaranteed.
There's something
more.
else big that's going to fall here.
There's a lot.
Who influenced her? Who was she around?
Yep.
Social media.
Yes.
And it's a death penalty qualifying case. Understand that. They theoretically are.
But at 17, she can't.
Oh, yeah. This is Georgia. We put people to death.
At 17?
It's an adult charge of murder, brother. We do that. It's demanded.
Now, what I do think there's going to be more to the story about every aspect of this, and that this case was investigated back in February, they combed social media then, and they've combed social media even today because there's all these commentating that's happening from people all over the place. But who did she go to school with? Who were her friends? Everything.
What's surprising to me is there may be other people. I mean, the first thing you do if you're her lawyers, hey, if there's somebody else, you make sure you throw them under the bus.
She's cooperating.
Right, she's cooperating, but there's no one else arrested yet. That's sort of shocking.
Who was her boyfriend? Was there sexual abuse is what I immediately thought of. I'm sorry, that's what I immediately thought of. The stepfather.
We're lawyers, so we have dirty minds because it just happens to be accurate too many times, and that's exactly where I go.
It's Menendez brothers stuff we're talking about.
But my other issue
no
is,
evidence of that.
When did this girl get told that she needed to go get a lawyer, and when did this young lady get a lawyer? Because when I hear a 17-year-old is cooperating with the investigation into the shooting of her parents as a lawyer, that's about as terrifying as you get.
Do you think it's surprising? I was surprised because she's 17 years old, obviously not a sophisticated criminal.
Impossible.
And they took their time. They took 5 months to arrest her.
Well, this is a serious arrest. Arrest the daughter and the stepdaughter. You better get this one right. You get this one wrong, there's your career.
Right, but I mean, how sophisticated of a crime could this possibly be by this 17-year-old with freckles?
But you have to get the forensics, the phone data.
Yeah.
You
and
have
it's
to
hard
get
because she lived in the house, so of course her fingerprints are everywhere. Of course her saliva's on the
and
dishes.
of course they had a Ring camera. You know there's that video. And there's poll cams out that way too. Come on.
And as common now, you go and slay and hang the victims. And the character assassin, they got to do that due diligence to make sure that the victims are not represented, but the state has a good view of who the victims really were.
And you get the
She
full
is
picture.
an adult.
But I think there's someone.
Yeah, she's an adult.
She's an adult, period.
I think maybe they're waiting to get the other person. They believe there might be more than one.
That was sure alluded to from that lady.
To me, that's the key to the whole thing. Thank you so much. Randy Kessler, Meg Strickler, Josh Schiffer. Appreciate it.
So, a 17-year-old kills her mother and stepdad for what good reason? Remind me again? They have no reason. But before I leave you on this story, I want to break this part of the story down. They have the teen's eulogy at the mother and stepfather's funeral. She She delivered a eulogy, and they want to break this down for you.
I'm Vinny Politan. We begin tonight with some breaking news. The verdict is in the widow's words.
You need oxygen first? Maybe. Okay, get some of your oxygen real quick.
Do you have your driver's license on you anywhere?
No, I've got a passport.
You don't even have a license?
But at this moment, the Carroll County Sheriff's Office has charged her with two counts of murder and 2 counts of aggravated assault. And I would suspect that more counts would follow in the indictment to come. In the beginning, when we responded to the scene, there was no signs of forced entry. There didn't appear to be a robbery. We had 2 victims that had been shot to death in the home that had a 17-year-old and a 5-year-old in it at the time. And she said she didn't hear any of the gunshots go off. That kind of makes you wonder and tilt your head a little bit. But of course, we had to collect evidence, as you know, and throughout this process, as I said yesterday, we have processed digital evidence, forensic evidence, DNA evidence, everything that we can to try to make a case and hold the right person accountable. We believe there absolutely positively could be other individuals involved. And we have been speaking with Sarah over the past couple of days and hoping to shed more light on that aspect of when you're investigating a crime, everything, we watch everything. As you know, I'm sure one of our main goals in an investigation is to look at every aspect. So, of course, we had investigators that attended the funeral because sometimes you will have things that happen, unfortunately, that might lead you in the direction of a suspect or give you pause. She seemed to be upset about her parents being murdered, but I was not there in person, so I don't know if there were actual tears when that happened. And she also said, I'm sorry at the end of it. She could have been apologizing for being upset, or it could have had a deeper meaning. We may never know.
What you say can and will be used against you in a court of law. That may be very relevant to what happened here. Take a look at this mugshot. This young woman is just 17 years old. She's got freckles on her face, should be living a good life, should be enjoying the summer, but she's not. She's been accused of shooting and killing her mother and her stepfather 5 months ago. She was arrested. She's now been charged. Now, what happened immediately after her mom and stepfather were murdered, there was, a service and a funeral and everything else. And she actually did the eulogy. And a relative of the stepfather, Kristen Dowda, shared video on Facebook of Sarah Patrick delivering that eulogy at the funeral.
I just wanted to say goodbye to my mom and Jamie since we never got the chance to. I was so used to you guys always being here to the point that I never once thought to imagine y'all not being here. I didn't have a single clue how much I needed y'all until now. Although there's nothing we can do to bring them back, we still have control over how we treat people with us today. I love you guys, and so do I. And so do they. I'm sorry.
A lot of people are talking about those last 2 words, I'm sorry. What is she sorry for? Let's bring back in our think tank. Still with us, Nima Rahmani, Sydney Rushing, and Matthew Mandino. Sydney, what are your thoughts about the I'm sorry at the end of the eulogy? She's 17 years old.
So I don't know if she's, as a defense attorney, I'd probably be saying that she's apologizing for, showing her emotion. A lot of times when people get choked up, they apologize for showing that emotion. Obviously what she's talking about is very emotional in and of itself, but do I think that they could definitely use that as a admission of hers? I can definitely see them trying to do so, but I could see that going either way.
Okay, Matthew, she is 17, so she posted about this on TikTok. Let's take a look.
doesn't know it, but a year from now, our family will be torn apart, and I will move far away and won't see or talk to him for 5 years.
What's going on here, Matthew? What's going on here? It took 5 months for an arrest, by the way. It took 5 months for an arrest. I can't imagine that a 17-year-old is a mastermind that could cover her tracks that well. What are your thoughts?
Well, it's really a disturbing case. I mean, obviously, we just looked at this video. We saw the eulogy. You know, she's trying to attract sympathy, to promote sympathy for herself because of deaths that she allegedly caused. I mean, if you look at this, it's you know, the matricide. You kill your mother to gain sympathy from the public. And, you know, she even reached out to a true crime influencer to look into the case. You know, wondering, you know, what's that about? Do you want to generate some publicity for yourself? Do you want to be on television and talk about this? I mean, it's very disturbing. We don't really know what the motive is, and you don't really need to have a motive if you have other evidence to support this. But it's really disturbing how it's evolved after the death that now she's alleged to have caused.
Nima, they say that they're talking to her, that she has been cooperative. They also say they believe others could be involved here. What is that process like, and what do you expect to be the result of all that?
Well, she's cooperating and naming names. We may see additional arrests soon. Look, it's tough to say, because, you know, during the press conference, law enforcement says they have a mountain of physical and forensic evidence. I mean, I do take them at their word, maybe because I'm a former prosecutor, but also because I don't think police officers are going to be arresting the daughter of 2 murder victims unless they had pretty overwhelming evidence. I mean, that would be an incredibly terrible look if this young woman were actually innocent, which I don't think she is. The question is, you know, why did she do it? And Matt's talked about this a little bit. Is it for the likes? We've seen people do horrible things on social media, violent things, sexual things, dangerous things, just for attention. And, you know, was she capable of doing this alone? You know, obviously we've seen young men and women, even as young as teenagers, commit murders. But what was the reason here? Was there a financial reason? Was there some resentment? I mean, why would someone kill their parents? And even though it's not an element of the crime, during the trial, if we get then, she may plead, she may cooperate. That's something that jurors are going to ask and prosecutors are going to have to answer.
And Sydney, to me, I feel like at this point, there's still a huge part of this story that has yet to make itself known. Like, and there's going to be something big that is going to happen one way or the other here.
That is exactly correct, Vinny. There is really not much here. We have someone who is charged with a crime, and we don't really have much more to that. So to even try and say that she did it and that we know for sure she did it, or even think that she did it without any other facts or anything else being put out there, I think is a kind of, you know, hard judgment to make there. It makes you raise your eyebrows a bit, right? She was, you know, she gave the eulogy. She said, I'm sorry. She turned herself in. She's being cooperative, but that doesn't mean she did it. So we have to wait and see this one out.
Yeah, there's a huge development in this. I think that's going to turn this thing into something much different than it is right now. It could just be the reason why, the alleged motive, or it could be someone else who's involved. But I think if they took the 5 months and they've arrested this young girl and charged her the way they've charged her in Georgia, they need to have the evidence to do that. Okay, Nima Rahmani, Sydney Rushing, Matthew Mangino, stick around. Up next, oh, Donna, there she is.
Okay, so 2 words. I'm sorry in that eulogy. But despite having all that evidence, all that physical evidence, and the and Sarah Grace Patrick on video during that eulogy saying I'm sorry, could that still mean she did it? Let's have to wait and see as this case progresses, because I believe the case is still being investigated. Now, earlier you heard me do my opening statement on this particular story, and it upsets me to even report this. But a son dies after mom allegedly leaves kids in a hot car while at the spa. This is in Bakersfield, California. I'll read part of the article and then we'll take you right to the video. A California mother is facing felony charges after she allegedly left her 2 children in a hot car for hours, resulting in the death of her 1-year-old son. 20-year-old Maya Hernandez pleaded not guilty to the charges of involuntary manslaughter and 2 counts of child cruelty on July 1st. According to Bakersfield police, officers responded on June 29th after learning 2 children were left inside a vehicle for 2 hours while their mother was at a medical spa. 1-year-old Emilio Gutierrez was pronounced dead at a local hospital with an internal temperature of 107 degrees. The 2-year-old, which I now found out that it was his 2-year-old brother, who had an internal temperature of 99 degrees, survived and was placed in protective custody. Relaying the news to Hernandez, documents say her response was admitting to knowing it was irresponsible and thought of it prior to leaving the car, but made the decision to leave them inside and not being able to justify it. According to a police report obtained by Scripps News Bakersfield prior to arriving at her appointment, Hernandez was messaged spa personnel asking if she could bring her children inside, receiving a response, "Sure, if you don't mind them waiting in the waiting room, hon." The report states Hernandez left her kids in the car while it was running with the AC set to 60 degrees. Documents say Hernandez's procedures only took 15 to 20 minutes, but the children were left in the car for almost 2 hours. It says that at no point did Hernandez come out to check on her kids. Even though Hernandez claimed to have left the children in the car with the air conditioner on, the car's manufacturer says that the car automatically turns off after an hour of inactivity. She went back to court earlier before the weekend. Here's a story courtesy of Court TV in its entirety.
What's trending in true crime is the community is mourning the death of a 1-year-old baby boy. His mother is facing manslaughter charges for allegedly leaving him in her hot car while she went to get lip filler.
I couldn't stop screaming. I just kept picturing them alone. I can't even imagine what they went through. They were strapped in their car seats. They couldn't even get up to save themselves. She literally locked them in their car seats and shut the doors.
This is so horrific. Police say Emilio Gutierrez and his 2-year-old brother were left in a hot car while temperatures reached over 100 degrees. This happened in California. So where was their mom? Well, police say she was inside of a doctor's office for a cosmetic appointment. The 2-year-old child fortunately survived, but the 1-year-old child, Emilio, died at a local hospital later. 20-year-old Maya Hernandez, his mother, was arraigned Wednesday on charges of involuntary manslaughter and child cruelty. Police say that her sons were left in the car for at least 90 minutes time without air conditioning. Vehicle's internal temperature reached up to 143 degrees. Police say that she had left the car on and running, so the air conditioning was running initially, but the car had a feature that it automatically shut it off after so much time. Now she's being held on $1 million bond, set to appear in court tomorrow for her preliminary hearing. So we're going to keep you posted on that. In the meantime, what do you think about this case? And will we hear of any defense for Maya Hernandez? Let's talk about it. Our legal eagles are still with us. John Phillips and Michael J. Brown want to welcome in parenting and family relationship expert and author Dr. Sue Kornbluth. Good morning to you all. Dr. Sue, let me start with you, please. Your thoughts on this mom?
Well, first of all, it's horrific, right? And people are feeling that way about this. But there are reasons sometimes things like this happen from a psychological standpoint. Many times this happens because of sleep deprivation or parent burnout or all kinds of different kinds of stress. The problem in this particular case that I see with this young lady is that she knew that she left them in the car with the air on. She turned the air conditioning on, knowing that she left them in that car. That seems intentional to me. And look, as a parent, sometimes we all feel burnout and we want to get our needs met and be pampered and do things like that, but not at the expense of our children.
Right, Dr. Sue. It's horrific. John Phillips, let me go to you next. Your thoughts, and is anything coming to mind early on in this stage of a defense for her, and anything you think we could possibly hear about tomorrow when she goes to court?
I've had multiple of these cases, including the loss of young Uriah Page, who there's a law in Florida, the Uriah's law, that resulted from her babysitter leaving in her car. And that babysitter, to the doctor's point, forgot, and that's the whole should we have a shoe back there kind of thing. This mom did not. And this mom infuriates me more than most moms because she was busy getting duck lips and Botox for 2 hours with her kids in the car. And to make matters worse, California law, as I understand it, says anybody under 6 cannot be left in a car for any reason with any supervision. So you did this on purpose while you're focused on your vanity. I hope the police, prosecutors, civil attorneys, it's kind of hard when it's your own child to have a wrongful death suit, but I hope they all come after her with full everything.
John, I'm sure so many people watching this segment now feel the exact same way. Thank you for all of that. Michael J. Brown, last but certainly not least on the panel on this question, your thoughts, and of course we've got to ask you if there's any defense you see for her in criminal court.
This is a tough one. John hit on two really good points. One is it's not a 2-minute running in for a quart of milk type of situation. This is vanity. This is getting your cosmetic surgery, and it's in excess of 90 minutes. Those are really two fatal factors for her on the criminal prosecution end. The only thing that struck me right off the bat when I read about this case initially, Julie, is, well, she had this belief that the car could run indefinitely with the air conditioning on, which would keep the temperature at 70 degrees or 72 degrees, and the kids would be okay. Again, nobody should leave kids strapped in a seat because they could have other issues independent of the heat. They may be in distress for other issues. So very difficult case to defend, but initially that's what I had thought about is, hey, I didn't know about this feature in my car. I thought it would run. I thought they would be okay. Try selling that to a jury. No way, but that's all we got to go with.
Great points. Michael, thank you for all of that.
I want to thank Julie Grant and her panel for the commentary on this case, and I will I'm going to have my closing statement regarding this as well, but I do want to say this. She knew what she was doing. She knew she had an option and didn't take it. So yes, whatever defense she wants to claim, it doesn't fly. Again, I'll address this case again in my closing statement. Next up, a trial date has been set for a realtor accused of holding women as quote-unquote sex slaves. This one's out of Milwaukee. Milwaukee realtor accused of holding women captive as sex slaves will face trial early next year. 38-year-old Austin Chronister appeared in court last Wednesday for a motion hearing on charges of human trafficking, false imprisonment, and 2 counts of second-degree assault. Prosecutors allege Chronister held 2 women captive and sexually assaulted them, branding them with slave tattoos and assigning them slave numbers. During that hearing, the defense argued for more clarity on the trafficking charges. The state responded that the allegations primarily involve harboring. The judge set a jury trial date of January 26 in 2026 with a motion hearing and final pretrial date scheduled for November 6, 2025. All discovery in the case must be completed by August 25th. And I am kind of interested in how that's going to turn out. Next up, this one's going to be rather tricky. It's a verdict watch, and it's from the Preppy Party murder trial. Raul Valle, State of Connecticut versus Raul Valle. And I'm gonna have to break down the way this verdict went. But first, we're gonna take you right to the courtroom as the verdict was being read.
Will the defendant, Raul Valle, please rise and face the jury? Do you find the defendant guilty or not guilty?
Not guilty.
We have to go through the docket number 8.
Oh, it's not on here. Sorry.
It's okay.
In docket number AAN CR 22-0189-418T, count 1 of the substitute information charges the defendant, Raul Valle, with the crime of murder in violation of section 53A-54A of the Connecticut General Statutes. Do you find the defendant guilty or not guilty?
Not guilty.
As to count 1 of the substitute information charging the defendant with the lesser included offense of manslaughter in the first degree intentional in violation of section 53A-55(a)(1) of the Connecticut General Statutes, do you find the defendant guilty or not guilty?
Not guilty.
According to direct the court's inquiry to the foreperson at the time, Mr. Foreperson, your note indicated that's Exhibit 10. Exhibit 10, your note indicated that the jury, after lengthy deliberations, was hopelessly deadlocked on manslaughter in the first degree, reckless, in violation of Connecticut General Statutes 53A, 55A, as the lesser included offense at count 1. Is that correct?
Yes, Your Honor.
All right, so you were unable to reach a unanimous verdict as to that particular charge. Is that correct?
That's correct.
Please continue on count 2.
Count 2 of the substitute information charges the defendant with the crime of assault in the first degree intentional in violation of section 53A-59(a)(1) of the Connecticut General Statutes. Do you find the defendant guilty or not guilty?
Not guilty.
Please pause. Mr. Foreperson, for Exhibit 10, again, the note that was sent to the court, provided to the court and marked, indicates to the court that after lengthy deliberations, the jury is hopelessly deadlocked on the charge of assault in the first degree, reckless, in violation of 53A-59(a)(3) as a lesser included offense. Count 2, is that correct?
That's correct.
All right, so you were unable to reach a unanimous verdict regarding that particular charge as the lesser included offense. That is correct.
That's correct.
Thank you. Madam Clerk, please continue on to count 3.
Count 3 of the substitute information charges the defendant with the crime of assault in the first degree intentional in violation of section 53A-59, paren A, paren 1 of the Connecticut General Statutes. Do you find the defendant guilty or not guilty?
Not guilty.
Madam Clerk, please pause. Again, Mr. Foreperson, Exhibit 10, Court Exhibit 10, your note to the court indicates that with respect to assault in the first degree, reckless, under count 3, after lengthy deliberations, the jury is hopelessly deadlocked on that charge as a lesser included offense. Is that correct?
Yes, it is.
So you were unable to reach a unanimous decision as to assault in the first degree, reckless, in violation of Connecticut General Statutes 53A, 59A3 as a lesser included offense under count 3. Is that correct?
Yes.
Thank you. Madam Clerk, please proceed to count 4.
Count 4 of the substitute information charges the defendant with the crime of assault in the second degree intentional in violation of section 53A-60, paren A, paren 2, the Connecticut General Statutes. Do you find the defendant guilty or not guilty?
Not guilty.
Madam Clerk, please pause. Mr. Foreperson, Court Exhibit 10, the note that was forwarded to the court indicates that at count 4, as to assault in the second degree, reckless, after lengthy deliberations, the jury was hopelessly deadlocked on the above charge. Is that correct?
That's correct.
All right, so is it correct that the jury was unable to reach a unanimous decision as to assault second degree reckless violation of Connecticut General Statutes, section 53A-60A3 at count 4?
Yes, Your Honor.
Thank you. Madam Clerk, you may proceed.
Your Honor, may the verdict be accepted and recorded?
Yes, the verdict shall be accepted and recorded.
Ladies and gentlemen of the jury, listen to your verdict as it is accepted and recorded. As to the first count of the substitute information charging the defendant with the crime of murder in violation of section 53A-54A, paren A of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.
As to count 1 of the substitute information charging the defendant with lesser included intentional violation of section 53A-55, paren A, paren 1 of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.
As to the second count of the substitute information charging the defendant with the crime of assault in the first degree intentional in violation of section 53A-59, paren A, paren 1 of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.
As to the third count of the substitute information charging the defendant with the crime of assault in the first degree intentional in violation of section 53A-59, paren A, paren 1 of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.
As to the fourth count of the substitute information charging the defendant with the crime of assault in the second degree intentional in violation of section 53A-60, paren A, paren 2 of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.
Ladies and gentlemen of the jury, please rise. You heard your verdict as it was accepted and recorded. You heard your verdict being read back as to each of the 4 counts. Is that your verdict? So say you all.
Yes.
Thank you. Ladies. Anything from counsel at this point?
No, Your Honor.
No, Your Honor. May we be seated?
I'm sorry?
May we be seated?
Yes, you may be seated. Okay. I, upon no request by counsel, the court is not going to hold the jury. So I won't have the hearing. All right, ladies and gentlemen of the jury, I'd like to address you. Take a moment your verdict has now been recorded. It's been accepted by the court. The court will deal with the outstanding remaining charges once I discharge you, but I want to say a few words to you before I do that. Your oath that you've been obligated to keep during this time, you've been obligated to stay silent, not discuss this case. I am now relieving you of the duty of your oath, so you are released from your oath. It is, of course, up to you to decide whether or not you wish to discuss this case with anyone or your role as a juror with anyone. You certainly have no obligation to do so. And please be aware that any comments that you shall make may become the cause for further proceedings concerning the verdict. I would like to take this time to recognize you and thank you for your very important service, serving as a juror, especially on a lengthy trial such as this. This takes you away from very important other aspects of your life. So I want to thank you for the time commitment that you gave to this case. I know that we originally asked you for a commitment through July 1st, and you have graciously given us your time for a rather extended period beyond that July 1st date. Inevitably, a decision by a jury will gratify one party and disappoint another. It's a very difficult job that you have. It's a difficult job for a juror to be asked to make a decision such as important ones like this. And I understand, and so does everyone involved, that the decision that you made here today is not an easy one. These are decisions, however, that are extremely important to our society, as well as the individual defendant. We all recognize that it's not an easy one, and we thank you for taking the time to reach the decision that you did reach here today. We're very grateful to you for performing that very important assignment.
Wow. Okay. Let's break down this entire verdict, because even I've been thrown for a loop as far as the way the verdict went. Okay. On count one against James James McGrath, they found Raul Valle not guilty. They found him not guilty on first-degree manslaughter, but they were hopelessly deadlocked on first-degree manslaughter reckless, which was a lesser included. On Ryan Hines, count two, as for assault in the first degree, they found Valle not guilty. On assault in the first degree, assault in the first degree reckless, assault in the second degree, and assault in the second degree reckless, the jury was hopelessly deadlocked. Now I'm using their exact words. Count three, on Thomas Connery. Assault in the first degree, Valle was found not guilty. Assault in the first degree reckless, assault in the second degree, assault in the second degree reckless, the jury was hopelessly deadlocked. And on count four, for Faison Teal, assault in the second degree, he was found not guilty, and assault in the second degree reckless, the jury was hopelessly deadlocked. So now, jokingly I can say this verdict is as clear as mud. The big question is, though, will they try him again on those lesser included charges, or will they just let it go and leave it at that? Because on the biggest charges of them all, Raul Valle was found not guilty. That's a question we'll have to wait for the answer for. Next up, a judge is ordering monitoring for Gregory Moore, who was charged in the Eliza Sherman murder. A former attorney has been charged in the death of Elisa Sherman, who was back in court on last Wednesday. Judge Kira Krivosh said Gregory Moore will be placed on court-supervised release and will be GPS monitored while the case proceeds. During that time, Moore is forbidden from traveling out of state or handling firearms. If Moore violates the terms of his GPS monitoring, he may be arrested without bond. At the hearing, Sherman's daughter Jennifer Sherman spoke about the impact of her mother's death and what it had on her family. Quote, "Our mother cannot stand here today to speak for herself, not by her own choice. So we stand here for her. We are her physical voice. We are her vessel. And while she is no longer with us in body, her spirit remains powerfully present in this courtroom, in our group, and in our pursuit for justice." Moore was released from jail last week on a $2 million bond. He is facing 1 count of aggravated murder, 1 count of conspiracy, 6 counts of murder, and 2 counts of kidnapping in Elisa's 2013 death. While this case may be new in your docket, our commitment to justice for Elisa is not, Jennifer said. For 4,491 days since March 24th of 2013, we have remained focused on 2 unchanging goals: to protect the public and to hold the person responsible for the murder accountable. Elisa, a 53-year-old mother of 4 and a Cleveland clinic nurse, was brutally stabbed in downtown Cleveland in broad daylight. At the time of her death, Moore was representing her in a divorce case. According to a secret indictment made public after Moore's arrest, he allegedly lured Elisa to where he worked, saying that he needed to meet with her, but didn't intend to meet with her at all. The indictment stated that this was part of a plan hatched months earlier to kidnap her to avoid having her try her divorce case in court. Moore's next pretrial hearing is scheduled for July 30th. And this is going to be one of those. This could be one of those cases where it's going to take a lot to bring this person down. That's all I got for that one. Here's one that really tore my guts in two. Shonda Vander Ark, a woman who was convicted of starving her child to death, was back in court requesting a new trial. We're going to go to Court TV for more information on this one.
You testified that you gave Timothy a warm bath the night before he passed away, that last night, July 5th. Do you recall that?
Yes, sir.
This is hours before he dies, right?
Yes, sir.
You look like that when you put him in the bathtub?
Leave him. Yeah, that piece of trash. Yeah, I see him. All right. Right. Please rise.
I know you remember that moment. That really was the moment from the tortured son murder trial, the cross-examination of convicted killer Shonda Vander Ark. And now this woman wants a new trial. So we're shining a spotlight on the upcoming hearing and the victim in the case. So on July 25th, this defendant is going to be back in court to make her request for a new trial in front of the judge. Now, she was already sentenced to life in prison without the possibility of parole for the death of her son Timothy back in 2022. This is Timothy. He was 15 at the time of his death. He was 5'8" and weighed only 69 pounds at autopsy. 69 pounds. 15. Now, according to testimony from his brother Paul, Timothy was routinely handcuffed, forced to eat hot sauce, and also forced to sleep in a closet.
That's the picture I want people to remember of your son. You took that from him. You took it from him. For what reason, I don't know. Mr. Johnson's right. There is something broken in you. I don't know what that is, but it doesn't negate what you did here. So besides remembering him like that, I'm not going to let you hide in the darkness anymore. People know what you are now. They know what you did. You're not able to hide in the darkness anymore.
It's the voice of attorney Matt Roberts fighting the good fight. He was the one who led the prosecution of this case. And he's going to be the one back in court as Shonda Vander Ark is trying to get a new trial. She's claiming she was in a catatonic state. She's claiming she was incompetent to stand trial at the time. And guess what? We're bringing Matt Roberts on the show this morning right now. He is the chief trial attorney in Muskegon County, Michigan. And since this trial, since we got to see him in action try that case so brilliantly, we've had him on many times. He's become one of our favorite legal analyst guests. Matt, thank you for making time on this this morning. We all have feelings should be back. Did you have a feeling that should be continuing to fight this?
Well, good morning, Julie. It's great to be here again. Yeah, certainly we had an expectation that there would be at some point an appeal filed, and this motion for new trial is not uncommon. It happens in most cases where there are trials, and it's certainly a step that we expected. Took a little bit longer than we expected. There was some difficulty apparently with the appointment of appellate counsel and some disagreements about how to proceed with the appeal, but not unexpected, certainly.
No, Matt, when she says things like she was incompetent to stand trial, I want to know what you were, because there's so much I could say, but we want to hear from you. When you were up there close and personal with her, doing that fantastic cross-examination where she, appears to get sick, don't know if she actually got sick or what exactly happened there. But our viewers were loving the fierce cross-examination that you did, getting justice for this precious boy. Did you see incompetency from her?
Certainly not, and it really gets back to what our central theme of our response to this motion is that she would pick and choose the moments where she believed that she was incompetent. It's a theme that really ran throughout the trial. It ran throughout the evaluation for whether or not she was criminally responsible, insanity defense, if you will, and it certainly showed itself in the cross-examination there, where every time I would ask her about one of the punishments or one of the difficult portions, she would say, "Oh, I don't remember that," and that's a theme that she would constantly go to, and in fact, even in her own evaluation by her own doctor that we're aware of, Dr. King, sort of the same thing, that this idea that she could just selectively pick out what parts she remembers and what she doesn't remember just does not line up with any diagnosable or any recognized mental illness that she was suffering from.
Right, Matt. To me, she's diabolical. The behavior, it's diabolical. I see her pathology. I look at her. She's a lawyer. For anybody who forgot that fun fact, she's a lawyer by profession. So this is not a stupid woman. This is somebody, to me, that I think is trying to find any way she can to remove herself from being responsible for what she did and what she directed her son Paul to do. Matt, let's take a look at that. He was one of your testifying witnesses, but also a defendant because he behaved badly here too at her direction. Let's listen to what he said about the hot sauce and poor Timothy.
Do you recall while Timothy was in the tub, an exchange where your mother inquired about pouring hot sauce on his private parts?
I do, yes.
Did you do that?
No. That was beyond rule, as everything else was.
My gosh. Matt, we've talked about this before, but I think it's worth a mention again. In terms of what you've seen over the years, you've had an illustrious career and prosecuted many child abuse cases. Where does this one stack up in terms of severity toward the others?
Well, this one is by far the worst case, and in fact, most of the people that have seen this case or touched this case would all say the same thing. The level of depravity here, it's just unfathomable, and that that example that you just pointed there, the Paul testifying about the remark about pouring hot sauce on privates, every time in this case we thought we had hit a new low, we'd find a new low. And the hot sauce on the privates was another one. The fact that she would even contemplate that. Now, thankfully, that appears to have not happened. And I think Paul was even the voice of reason there. But just the idea that somebody would even contemplate that just shows, again, that level of depravity that is just unconscionable and unfathomable.
It really is. We've got some text messages between Paul and defendant John DeVander Ark, and these were read out loud in court. And so talking about feeding Timothy. Let's take a listen to this moment now.
What the heck has he been doing?
According to him, he's just been setting. I don't know, though. I didn't know he was awake.
Find out what he has snuck right the heck now, because I know he has snuck stuff since you weren't doing what you were supposed to. Tell him he just restarted his not eating again.
If he stops many more, let me handle him, please.
No.
Wall sits.
Push him until it looks like he's about to fall over, please.
Oh my gosh, it's sickening. Matt, God bless you for doing the work you do, because it is hard to be a prosecutor, and it's even harder to handle child abuse cases. It takes a really special person to do that kind of work, and thank goodness you do. Tell us, please, what we can expect when she comes to court next week. July 25th is the date. How's this going to go?
Well, we obviously will be making our arguments here. The defense's argument rests largely on this competency issue, the fact that she, in our view, chose to not return to court, and just kind of sort of play into that theme of, well, I'm not competent, I don't understand what's going on, I can't participate in those things. It just is really not supported by the record. It's not supported by any doctor, and any claim that another doctor might have reached another conclusion is just foolish, because the defense had multiple opportunities to present a doctor that would say that she actually suffered from a condition. So that's the main crux of the argument. I don't anticipate the judge will have a difficulty ruling on this case, but obviously we'll have to wait and see and make our arguments. But we'll be very vociferous in our objection to this motion for a new trial here. I think this issue has been well litigated, and we believe that the conviction is certainly solid here, and that will be our position to the court.
Yes, I would agree with you 100%, Matt. Looking back at that moment, we were just playing it while you were talking about what's coming up in this hearing, and you see her seeming like she's getting ill there, and all I keep thinking about is, you know, she saw her child. She got ill there when you were showing her the autopsy photo, and you did that great cross and making her look at that. She was looking at her son every day of her life, you know, and so it's a shame she didn't get sick like this sooner, isn't it, Matt? It's a shame she didn't get sick before that poor angel was starved to be 69 pounds. I look at this video, it is infuriating to me. What goes through your mind, and what emotions do you have when you see this tape rolled back now?
Well, certainly looking back on it, I agree with you. It is infuriating. It's clearly just a ploy, and even talking to the jury, the ones who could see her, certainly even better than I could see her because of their position in the courtroom, had no belief that was a real moment, that she was actually getting sick. In the moment, I just wanted to get away from there. I didn't know exactly what was taking place. But yes, looking back, it's clearly orchestrated. It's an effort on her part to drum up some sympathy. But the most important part about that is that she had seen those photographs, those exact photographs, less than a week before that, and had absolutely no reaction. So that just tells you everything you need to know right there.
Exactly. Pants on fire. You know, and thank you for sharing that with us, Matt, you know, because we can assume she'll be looking at the discovery, seeing the photos, and that was all her trying to win the Academy Award there in the courtroom. Didn't work. You picked a great jury. They saw right through that. Matt Roberts, you're the best. Thank you so much for making time for us this morning. We'll let you get off to court.
And I want to thank Matt Roberts as well for being the prosecutor in that case. And I want to give Shonda Vander Ark a round of applause for that Emmy, that Oscar, and that Tony Award-winning performance she did in court. That's all you get. As far as my opinion, as far as whether you should get a new trial or not, Shonda Vander Ark, Nah. Whether you got sick or not, you deserve to get sick after seeing the autopsy photo of what you did to your 15-year-old son. You deserved every last second of that illness, every last second of that sickness. I mean, you starved the boy to death and he was only 69 pounds at 15 years of age. I mean, what was going through your mind? Julie Grant, I love your coverage on Court TV in the mornings, but this is one time I must disagree with you. Despite the fact that she's a lawyer, I would say Shonda Vander Ark is a stupid woman, because she should know one thing when it comes to criminal cases. You can run all you want to, but eventually you're gonna get caught, and that's what happened to her. Next up, the death of a Maine paddleboarder is being investigated as a homicide. This is out of Union, Maine. Police are investigating the death of a paddleboarder near a campground in rural Maine as a homicide and asking the public for help finding the killer. The body of 48-year-old Sunshine Stewart of Tennant's Harbor, Maine, was found last Thursday on Crawford Pond in Union. The manner of death was determined to be a homicide, though the cause of death is not being released to the public yet. That's according to Maine State Police. Police have asked anyone who may have seen Stewart paddleboarding on July 2nd between 6 and 9 p.m. near a 100-acre island on Crawford Pond contact them. Maine State Police said last Wednesday in an evening statement, it remains steadfast in our efforts to investigate the killing. Stewart lived about a half hour from the pond, which is a popular summer destination about 15 miles from the scenic coastal areas of the state's mid-coast region. Friends and family who gathered at Stewart's home on Wednesday declined to comment. Crawford Pond is located in the 2,400 resident town of Union, about 80 miles northeast of Portland, Maine, the largest city in the state. The area is popular with campers and day trippers. The pond is approximately 600 acres and does not have public access. It is available for a variety of uses, including boating and fishing. The 100-acre island preserve in the center of the pond is a wooded island reachable by canoe, kayak, or paddleboard from a nearby campground. The lake has numerous nooks and narrow areas, so it's possible there were other boaters on the water at the time of the killing who were unaware someone was in danger. Police have asked residents to remain aware of their surroundings and report suspicious behavior. Maine State Police said on last Wednesday they have been reviewing leads and tips and are sensitive to the way the killing has unnerved the community. Maine State Police recognizes the fear and discomfort that this incident has brought to the town of Union and the Crawford Pond community, the agency said in a statement that called on residents to remain vigilant. Loved ones of Stewart, who was known as Sunny to friends, launched a GoFundMe page in her honor in the wake of her death. The page states that arrangements and memorial service dates are still being determined. By last Wednesday, the page had raised more than $19,000. Today is a somber day for our family and friends. We've unexpectedly lost the light in our lives that was Sunny, the page said. The killing is a shock to the community, where family trips to the lake are a summertime staple, said Debbie Hilt, who lives in the area. Hilt says she knew Stewart as a child and knew her to be a regular user of the lake as an adult. Hilt described the island on the lake as a draw for campers looking for a quiet, secluded location. I've been on the lake since the early 60s. I grew up down there since I was 8 years old, she said. I don't even remember anything like this. Catherine Lunt, the owner of the nearby campground, which is called Micmac Cove Campground, said in a Facebook post that authorities have been using the campground to access the crime scene. The crime scene is not located on the campground itself, according to the post. Lunt said in that post that her business is not commenting on the investigation other than to say it's cooperating with authorities who are working the scene. Investigators have been doing their job, and we do not need media distractions at this time. So the only thing we have to worry about now is let the investigation continue, and when a suspect is revealed, we'll have more coverage on it then. Okay, the search for Travis Decker in Idaho has come to an end after they spotted someone who nearly fit the description but was cleared. Alright. This is in the Sawtooth National Forest in Idaho, following a possible sighting of Travis Decker, who was wanted in connection with the murders of his 3 young daughters in Washington State. U.S. Marshals have confirmed the person spotted was not the suspect. Over the 4th of July weekend, the agency received a tip about a possible Travis Decker sighting in the Sawtooth National Forest. A second, unrelated tip soon corroborated the initial report. On last Wednesday, however, the U.S. Marshal Service Greater Idaho Fugitive Task Force announced they had located the man who was reported and verified it. It was not Decker. The hiker, who is the same height and roughly the same weight as Decker, also has dark features, a beard, and tattoos on his arm and calf, explained the U.S. Marshal Service in a press release. Officials say that the man who was cooperative and confirmed that he had been hiking in the Bear Creek area the previous weekend. Law enforcement has now called off the search for Decker in the Sawtooth National Forest. Now, crime fighters, I've said this to anybody that'll hear me, but I'm gonna say it here right now. Wherever Travis Decker is, if he is still alive, Travis Decker is waiting for police to call off the search for the day. What he's doing is waiting for the cloak of darkness for him to make his moves. He'll move and keep going until sunrise, and he'll hide. And when he does, he's gonna make a mistake. He's gonna be spotted by somebody who's gonna make that call and report seeing him. When that happens, that's gonna be the mistake that's gonna get him caught, and that's gonna be the mistake that will turn him into authorities. That's how I see it. Travis Decker is moving. If he's alive, he's moving under the cloak of darkness. Well. Guess who's back in court, ladies and gentlemen? Sarah Boone. Sarah Boone is back. She's filing an inquiry complaining about her appellate attorney. But then again, come on, it's Sarah Boone. Of course she's going to complain about her appellate attorney. Here's
It's my name. Don't wear it up.
This is a box. This is the box where George Torres was killed.
We, the jury, find the defendant guilty of murder in the second degree.
We respect the jury's decision. I'm sure that Sarah Boone is going to want to appeal.
Might be hard to believe, my friends, but convicted killer Sarah Boone is happy. So what is it this time? According to Boone, her appellate attorney is ghosting her. Sarah Boone is serving a life sentence for murdering her boyfriend, George Torres. It happened in a suitcase. She zipped him up inside of a suitcase, beat the suitcase with a baseball bat, and left him in there to die. Now, back to her claim of ghosting. Perhaps it's relating to the fact that Boone has reportedly gone through at least 10 attorneys. So how is her formal inquiry of not hearing from her appellate attorney going to tip the scales of justice with her appeal? She's got to file it soon, we know that. Let's bring in our legal eagles, Jennifer Brandt and Tommy Pope, on the show this morning. Okay, are we surprised here that she's having trouble with this lawyer? I see you both smiling. Tommy, start us off. Your thoughts, please.
She's the gift that keeps on giving, Julie. I think, it's ironic. We've seen, and not the stereotype, but we've seen a number of cases where it's like the defendant loves, and it's been female defendants that come to my mind that love the attention. They don't care what's going on in court. They're going down in flames, but they like being there. And I think her being dissatisfied is part of her way of getting attention. Appellate process takes time. There's a lot of paperwork to be filed. But by her being dissatisfied, she gets to be the center instead of the process being the center. And I think that's what we've seen her do from the beginning. I think that's why we were all laughing. But that nothing surprises me with her. She needs to just go to prison and be quiet and stay there.
Right, Tommy. I know. Just go have a seat somewhere. But we'll keep hearing from her. I remember saying one of my predictions for 2025 was we're going to keep hearing from Sarah Boone. So got that one right. Oh, Jennifer Brandt, your thoughts on this lady?
Well, she's complaining again about her lawyer. We're not surprised about that because we've heard it 9 or 10 times already. But the appellate process does have very strict deadlines. So, if her lawyer is really not meeting those deadlines, it could jeopardize her appeal. I understand that she has already gotten an extension to file her appeal until September 1st. So, her lawyer does need to get on it. And, knowing Sarah Boone, she's not going to let anything slip. So her lawyer or any future lawyer will be prepared to hear from her. The judge, she wrote a letter to the judge after the trial. I mean, she's not going to sit quietly and let the process pass her by.
Jen, you're so right. I like what you said about how she won't let anything slip. Think about it for a second. What would it be like being her attorney? I mean, what would, you're both shaking your heads. Would you ever take on that case? My gosh. Jen, what do you think it would be like working with her?
I can't imagine. She is probably a very, very difficult client who is very demanding for sure and is not happy with anything that anybody does for her. She's one of those people that just wants the blame on everybody else. We heard it during her trial. It's never going to be her fault. So being her attorney would just be a total nightmare. That's for sure.
Definitely. I feel so bad for all those lawyers. I think they should all get medals for tolerating her. Tommy Pope, what would you think it would be like working with Sarah Boone?
Well, I was thinking it could be entertaining. I was going to say, though, as far as her future lawyers, some are probably taking the LSAT right now or just now taking the bar exam. they're in line to be lawyers one day. You know, if you didn't actually have to do the work, it could be entertaining because I would just agree with every complaint and everybody's doing you wrong. She'd love me because if you didn't have to do the job. The problem is maybe the reason the appellate lawyer's ghosting her is because they need to do the work. Just like Jennifer said, you got deadlines, there's pressure there. And to hear Sarah, well, I want to read the last draft that you did. How about let me get it done and then you can take a look at it. Her meddling, it'd be difficult.
Oh yeah, I'm trying to imagine. Yeah, entertaining. Yes, and I've tried to imagine. I feel like the documentation would have to be next level if you're the lawyer, because like Jennifer said, it's every little thing with her, and she's always finding fault with someone, something. Like you said, Tommy, she wants to put the attention, everywhere else, but on her. She distracts with her issues and coming up with things, and doesn't want to take accountability for killing George Torres, her boyfriend. So I feel like you'd have to just really just cover your tail if you were that lawyer, like everything you tell her and what she says back, because she's just, we've seen the viciousness come out with Sarah Boone. So what do we think is going to happen on appeal? Let's turn to that for a moment. Quick thoughts from you both. Jennifer, let me begin with you. Do you think this is going to go well for Ms. Boone?
I really don't. I mean, I think it was a rock solid case. I really just don't see how she's going to get out of this on any kind of error or anything that, may have been done wrong. I know she's complaining about her attorneys, that they did her wrong. I mean, everybody did her wrong. But bottom line, I mean, we heard the evidence and it was pretty strong. So I really don't think, I understand why she wants to appeal, but I don't think that the outcome is going to change for her.
Yeah, I'm with you. Tommy, what do you think? You think she's got a prayer?
Yeah. No, I agree with Jennifer. I think, and she's lost credibility. So when you have these kind of discretionary decisions, where the court will look a little deeper, I don't think, she's lost credibility. So something that might normally give a harder look, I think you're going to say, well, the defendant themselves orchestrated some of this by their conduct in court or things of that nature. And, the judge was mean to me or whatever. So I agree with Jennifer. I think it's part of our system, but I don't think it's going anywhere.
I'll make it 3 for 3. She's staying in prison. That's what I think. My next prediction with Sarah Boone. We'll be covering this hearing, whatever it happens.
Julie. Like Nostradamus. Julie.
Julie, I love it.
This I gotta agree with them. First of all, let me pull. I just pulled a comment up, and I posted this story on my community page. Caddy, Texas gal said, "What I want to know is anyone really surprised this chick would do that with not 1, not 2, but 3 tearful laughing emojis?" My response to that was simply this: I feel you. It's Sarah freaking Boone, the convicted criminal defendant Karen. Of course she's gonna complain about her attorney who's trying to appeal her conviction, just like the expert panel just mentioned, both Jennifer and Tommy. Shout out to them, and shout out to Julie Grant for making the prediction that she would have something else to complain about. And as for their predictions as far as Sarah Boone's staying behind bars, let's see, that's 3 for 3. Make me add me, call it 4 for 4. Sarah Boone stays behind bars. Appeal denied. Next up, a Washington man charged in abortion pill case is expected back in court, or at least he was back in court. But this was the latest update that I have. Hi. he was back in court because he pled guilty. A former nurse practitioner in Washington State pleaded guilty to assaulting his mistress and forcing abortion pills inside her at a plea hearing this past Friday. David Coots pleaded guilty to assault in the second degree with domestic violence, tampering with a witness, and assault in the fourth degree with sexual motivation. He was sentenced to 12 months and a day in custody, followed by a year in community custody. He was also ordered to have no contact with the victim. Court documents revealed Coots and the victim met in January 2023 when she went to his office for an appointment as a patient. The victim told police she had a positive pregnancy test a year later. Days after the positive test, she claimed Coots inserted a pill inside her without her knowledge while having consensual sex. She went to the emergency room after finding a white round pill on the toilet paper the size of an Altoid. She immediately texted Coots and asked what it was, to which he eventually told her he put 4 pills inside her that causes miscarriages. That was stated in a probable cause affidavit. The victim went to the emergency room where a rape kit was performed. The woman filed a protection order against Coots, and he was arrested on March 11, 2024, after violating the conditions when he showed up where she was staying with gifts and a letter. He was later released on a $500,000 bond and ordered to wear an ankle monitor, which he was permitted to remove last month, according to the News Tribune. Coots had previously pleaded not guilty to second-degree assault, third-degree rape, tampering with a witness, and 5 counts of violation of a court order. At the hearing, the victim said coming forward has been humiliating, and she lives in fear for her and her child's safety. The victim detailed their relationship, saying Coots relentlessly pursued her, and she eventually gave in, not knowing he was married. She said once she found out he was married, he presented her with what she later figured out were fake divorce documents. When she found out she was pregnant, the victim said she gave Coots the option not to be involved in the pregnancy, but instead he was thrilled. In describing the assault, the victim said she was shocked and devastated at the realization of what had been done to her while at the hospital. She also detailed multiple instances of Coots trying to contact her after the miscarriage, including Melissa Coots attempting to pay her off. The victim begged the judge not to fall for Coots' act, calling him manipulative and dangerous. Coots' defense told the judge that it's their belief the victim was not pregnant when she went to the emergency room, and his actions did not cause a miscarriage, while acknowledging what he did was unthinkable and completely out of character. Coots himself then addressed the court, saying he took full responsibility for his actions, letting fear and desperation guide him. He thanked his defense team and prosecutors and apologized to the victim and his family. Coots' wife, Melissa, pleaded guilty to a charge of attempted witness tampering and was given a 2-year deferred sentence last summer. Well, you did what you did. Now you got to suffer the consequences. Sure, the time isn't that long, but it's still you suffer consequences. Next, a teen pleads not guilty in a fatal shooting of his brother during a family fight. A Massachusetts teen pleaded not guilty to second-degree murder in the shooting death of his older brother in what his attorney described as a family fight that escalated to deadly self-defense. 17-year-old Jalen Lambert appeared in Bristol County Superior Court for an arraignment on charges of second-degree murder, possession of a large-capacity firearm, and possession of a firearm without a permit in connection with the March 15 death of 20-year-old Jaleel Simmons. Prosecutors argued Lambert should be held without bond, claiming he shot his brother in the chest during an argument over money in the family home. Oh, there we go, money. I would suggest to the court that based on the nature and circumstances of this incident, that this is obviously an extremely serious case, Assistant District Attorney Matthew Lopez said. Not only is this defendant dangerous, but there are no conditions of release that would ensure the safety of the public. According to prosecutors, the incident began when Lambert's mother asked him to return birthday money she had given him 3 days earlier because his older brother spent the family's grocery money. The verbal dispute between the brothers allegedly turned physical, with Simmons grabbing Lambert around the neck, choking him for 10 to 15 minutes, according to testimony their mother provided to a grand jury. After separating, the brothers continued arguing, with their mother attempting to call 911 multiple times. The prosecution says she saw Lambert holding a gun with a large capacity magazine before he fired a single shot into Simmons' chest after Simmons punched Lambert. The mother allegedly told the grand jury she did not know where the gun came from and had never seen it before this incident. When police arrived, Lambert immediately identified himself as the shooter, saying, it was me, according to the prosecutor. Body cam footage shows Lambert in distress, Lopez said, indicating that it wasn't supposed to happen the way it happened, and expressing regret. Defense attorney Rosemary Scapicio argued Lambert acted to protect himself and his mother. Scapicio said Simmons was larger than Lambert and had allegedly assaulted his younger brother in the past. Scapicio referenced an alleged altercation in which she said Simmons held Lambert against the radiator, leaving burn marks on his back. On at least 2 occasions during this altercation, Jalil had his hands around my client's neck, squeezing the life out of him, causing Lambert to act in complete self-defense and defense of others, Scapicio told the court. I don't know who introduced the gun. The Commonwealth doesn't know who introduced the gun. All I know is the gun doesn't get introduced until after the mother gets pushed to the ground. My client has to help his disabled mother, up, and then he's attacked again by Jalil. Scapicio argued in favor of bond, saying Lambert is not a threat to the community because the only person with whom he had problems, his brother, was dead. She added Lambert's family was rooting for his release, but they could only cobble together $6,200 for bail. If you look at the body cam footage, he is sobbing, literally sobbing, when the police get there. This was not something that he wanted to have happen, Scapicio said. Superior Court Judge William M. White Jr. took the matter under advisement, with the next court date scheduled for September 5th. Lambert is being tried as an adult per Massachusetts law. He is currently being held without bail in a Department of Youth Services facility pending the judge's decision on his dangerousness, which is what the attorneys argued. In Massachusetts, a dangerousness hearing is akin to a bail hearing in other states. According to his attorney, he's been in school full-time while in custody and has earned A's and B's. He's earning A's and B's, but right now he gets an F under the subheading, "Am I my brother's keeper?" Here's the next Karen Reid update. She files a motion to dismiss the wrongful death suit. And that's another one that we may have to wait to see how that goes. Weeks after she was acquitted of charges that she murdered her boyfriend, Boston police officer John O'Keefe, Karen Reid has filed a motion to dismiss the O'Keefe's family civil suit against her. A jury cleared Reef of charges that she murdered O'Keefe after prosecutors had said she hit him with her Lexus SUV and left him to die in the snow after a night out drinking. While Reed no longer faces any criminal charges related to O'Keefe's death, his family filed a wrongful death lawsuit in 2024, naming her and the bars the couple attended as defendants. The case was put on hold pending the outcome of Reed's criminal trial, which concluded in June, after Reed stating that being forced to participate in the case would violate her Fifth Amendment protection against self-incrimination. Following her acquittal, Reed added three new attorneys to her defense team: Aaron Rosenberg, Charles Waters, and Damon Seligson. On last Wednesday, Reed's team filed a notice of motion to dismiss the case against her. The full motion has not yet been filed with the court and is not available for public review, and no hearing has been scheduled. So basically, we're on a wait and see game to see what occurs next. Next up, we have a verdict watch in the Widow's Words murder trial. State of Iowa versus Karina Cooper. We are going to take you inside the courtroom for that right now.
All right, I have a form of verdict. For form of verdict 2, we, the jury, find the defendant, Karina Cooper, guilty of the offense of murder in the first degree, dated this 11th day of July, 2025. And juror number 1, is that the jury's verdict?
Yes, it is, Your Honor.
Would you like the jury polled, Ms. Watt? All right. Ladies and gentlemen of the jury, at this point, I'm going to ask that you return to the jury room with Ms. Davis just for a bit. We have a couple matters we need to wrap up here, and then I will come and talk to you in just a bit before I release you from your obligations in this case. So thank you, and we'll see you in just a few minutes. Go ahead and have a seat.
So, an Iowa jury convicted Karina Cooper of first-degree murder in the death of her husband, Ryan. Karina will face a mandatory sentence of life in prison without parole at her sentencing. According to testimony, Ryan was found with 2 gunshot wounds to his face in their trailer home on June 18, 2021. A deputy noted Ryan's body was in a recliner and Karina was sitting on top of him. The couple's 3 children were also in the home. Deputies found no gun at the scene, but did recover a .22 shell casing. The case went unsolved for nearly 3 years until Karina was arrested and charged with first-degree murder in February 2024. 2 months later, the co-defendant, Houston Danker, was also arrested on first-degree murder charge for acting in concert with Karina to kill Ryan. Danker is currently scheduled to go to trial in August. In their opening statement, prosecutors argued Karina and Danker were having an affair and plotted to kill Ryan to collect $500,000 in life insurance. The defense argued that Danker alone killed Ryan, describing him as a manipulative lover who pulled Karina into a, quote, fantasy of starting a new family, end quote. So, a panel of 12 says Karina Cooper is guilty of killing her husband, and now she is preparing to sentence her to life in prison with no chance of parole. What can I say? That's justice. Next, Donna Adelson was in court. She was in court for a motions hearing ahead of her trial in August. Now that one's got so many moving parts, it's not funny. Let's go to Court TV for coverage in this particular story.
Good afternoon, Your Honor.
Good afternoon, Judge.
We're here this afternoon in State versus Donna Adelson, 2023 CF 3226. Two motions we're here for this afternoon will be the defense's motion to compel and also the defense's motion to extend previously ordered deadlines for witnesses, exhibits, and pretrial motions in completing discovery. Part of the reason I believe we need to have a hearing on these matters as well, and I'll let you make your argument in just a moment, Mr. Zillman. Have you discussed with your client specifically as it relates to the raw data that you are seeking, specifically for Charles Adelson and herself, that this has the potential to reopening the door of the conflict?
Your Honor, I don't think that it would. It's in the same category as the emails that Your Honor authorized us to obtain in April, the raw, unredacted, unfiltered emails from our client's own account.
While they are certainly discoverable and while you have an interest in using them to prepare for, the question remains. Have you discussed with your client the possibility of this reopening the door to any conflicts?
No, we have not, because I don't think that it would reopen the door.
Very well. You may make your argument.
So, Your Honor, you may recall a number of times we've been before the court, and the defense, as laid out in the motion to compel, we have been asking for the raw, unredacted downloads, the emails, and we were repeatedly told that that had been provided to us. When we were able to retain an independent forensic data expert and provided them with the materials that we had been provided, we were informed that those are not the raw forensic extractions. And I was asked to obtain the raw forensic extractions. And in the motion to compel, I actually cut and paste the expert's explanation. I'm not going to try to paraphrase it. It's an explanation that he provided as to why it is his recommendation that we obtain the raw forensic extractions. That's what I did. I've requested that. It's taken, we're now a month since I made that further request, and I believe that we're entitled to that. I think the rule provides that, and our intent, in part, is to verify the cell brights that the state has prepared. The only way to do that, according to our expert, is to obtain the raw extractions from the state. And that's why we're asking for that, Your Honor.
Ms. Kettleman, you may respond.
No objection, Your Honor. I would just ask that whatever reports are generated by their expert as a result of that data being re-celebrated be provided to my office in a timely manner, because I'm advised, based on the version of the program and the type of program they use to produce a report, to verify our report, there could be some small differences involved. So I would like to not be surprised with that at trial.
Well, after that, I will grant the defense's motion to compel. As to the issue of the conflict, specifically Mr. Zellman, in part, when we had the first case management, I had counsel verify that they had no conflict as far as giving conflict-free representation to Mrs. Adelson. Should anything change with your review of these cell brights that may include communications from prior counsel or deal with matters that pertain to information that was provided by Charles Adelson, at that point, we are going to have to revisit the issue. Does everyone understand those?
Yes, sir. May I approach with a proposed order?
You may.
Okay.
Thank you. Your Honor, just to provide the court, Mr. Corbett and the defense expert have been communicating over the last 18 hours or so that once that order was signed, Sergeant Corbett was going to upload that to a portal that they've already tested this morning, so that our expert can download it. That'll be the fastest way for them to do that. He said as soon as, Sergeant Corbett indicated that as soon as he was given instructions to start the process, he would do so.
Right. As to the second motion, the extending of all deadlines for the defense. In particular, we've already had two extensions that have been provided by the court, first from the April 30th deadline, second from the May deadline. Does the defense have any motions that are unrelated to the new discovery?
No, Your Honor.
All right. As to the motions that you believe you still need to file that are in some way related to this discovery, what is preventing these motions from being filed and you seeking leave to amend as necessary?
Your Honor, due to scheduling, we were only able to depose Mr. Newland and Sergeant Corbett Wednesday, Thursday. We are deposing Special Agent Pat Sandberg, I believe, on this coming Tuesday. Before filing those motions, I think it's appropriate to make sure that there's a good faith basis to do so, and having those depositions, that testimony is, in my opinion, is necessary before we can do that.
Right. And I believe there are some other depositions that are scheduled for July, or I believe next week as well.
Yes, sir. We have them on Monday as well, and maybe Tuesday and Thursday.
Part of the reason that we have, whether it be discovery or any sort of deadline cutoffs in any case, is not simply arbitrary of the judge just saying, get it done by a certain date. It is so we can proceed orderly to trial. I believe your proposed dates were to within 4 weeks of when you believe the state has fulfilled its obligation. That's when you want to file your motions.
Well, Your Honor, given that we filed these on June 27th, we're obviously 2 weeks past that.
Oh, yes, we are.
And it's certainly not our intent to do anything to delay the commencement of the trial as scheduled.
The proposed date of when this would occur is not specific. It's not certain. It's pretty much a moving piece of jello. Is there anything that you can do to convince me that it's otherwise going to be a specific date in what you're asking to do with filing these motions several weeks after you believe the state has complied?
Unfortunately, it has been a moving target because we have not received all of the discovery from the state. During the depositions, during yesterday's deposition, we learned that he had conducted call frequency analysis between Donna Adelson and Charlie Adelson for a longer period of time than that had been previously disclosed. He is going to send us that if he had completed a report. He's also sending us the PDFs of the actual call frequency analysis that's contained in the demonstrative, because those are just excerpts of the call frequency analysis. So he's going to be sending us the completed call frequency analysis. So I say that to demonstrate that it is difficult for the defense to file any appropriate motions or to provide appropriate responsive either demonstratives or exhibits when we still have not received everything from the state.
At the same time, to file, and how many motions are we talking about at this point?
Potentially 3, Your Honor.
As to these 3 motions, would any of them affect the ability to actually move forward with trial on August 19th?
No, I don't believe so. None of them are just positive.
Very well. Do you have any further argument in support of your motion?
No, Your Honor.
Ms. Kappelman.
No objection, Your Honor. We've just asked that we be given the same grace. I'm aware of at least 1 or 2 more things that the state intends to do that could, need to be done past the deadline. So all indications are that both sides are working diligently to get this done. I understand your comment about the Jell-O, and I've got a couple orders myself of Jell-O that I'm wrangling, so I'm trying to minimize it, but things do come up past the deadline, so we're going to have to work
Ms.
through those
Kappelman
things.
specifically asked these emails, which has contributed to this. What is it else that you believe is going to come up on the state's behalf?
The emails?
I said, other than the emails,
What do I
is
think
going
is
to
going
come
to
up
come
on the
up?
state's
There's a
behalf?
defense witness that's been listed that the state has discussed trying to depose and may try to get that done before the deadline. There's a handwriting expert that the defense is aware of, that a handwriting expert There's a handwriting expert that the defense is aware of, that a handwriting expert exists, but they haven't been given the name or the report yet. I don't have the report yet. So that's something that's pending that would be in violation of Your Honor's order. So there are a couple outstanding issues that I'm aware of. I was not aware of the issue that the defense just brought up regarding Corbett having done a report, but he does do work to generate slides that were prepared and discovered by the discovery deadline. When asked about how did you come to those conclusions in deposition, he's going to say, I looked at the data. Well, they want to see that data. Okay, we don't object to that, but I don't think that's the same thing as a discovery violation.
The final pretrial hearing is August 8th. As to the date of when all motions need to be filed, so we can have a meaningful hearing on August 8th and proceed to an orderly trial on the merits. These motions are going to need to be filed by July 21st. Any motion that is not filed by either the state or the defense by that date, the issues are subject to being deemed as waived. If you need to seek leave to amend as to the specific motions that will be filed on this date, you may certainly do so. However, again, this is not just arbitrary date making to throw something out. If we are going to in fact have a trial on the merits that will be orderly, both parties, needed to see what you intend to raise as pretrial legal issues that the court needs to rule upon. There is not going to be a trial by surprise, either for the state or for the defense. Am I making myself clear?
Yes, Your Honor.
Yes, Your Honor.
Will you state those dates one more time? Motions to be filed by July 21st and final motion hearings on August 8th. Is that correct?
The final pretrial hearing is on August 8th. This time has already been set apart by a previous order. As to the motions in limine that have been filed, I believe the defense has renewed its motion concerning the Latin Kings. Is that correct?
Yes, Your Honor.
Has the state filed any motion in limine by the previous deadline?
We renewed motions that were filed previously. There's nothing new.
Well, as previously ordered, copies of all of these motions, when they are filed, they need to be served upon the court. Please do so if you've not already done that regarding what has already been filed. The next date that we will have, unless there are other issues that need to be addressed, will be August 8th. Does either party have anything it needs to raise?
Nothing from the state, Your Honor.
Can I have a moment, Your Honor?
Go ahead.
Nothing at this time, Your Honor.
Well, we are in recess for this afternoon.
Thank you, Your Honor.
You can, yeah, go ahead. What's that? It's good to file as is.
Okay, you heard it here first. That the trial will go on as scheduled on August 19th in Tallahassee, Florida. I've got a couple stories left before my closing arguments, and one of them is a woman murdering a man with a hammer and left a note in green highlighter. Murders a man with a hammer and leaves a note in green highlighter. Let's see where we're going with this one. Come on. Oh, brother, please. There we go. Alright, let me reload this page. Hang on, guys. Seriously. Are you kidding me? Right now. Apparently, this next story doesn't want to cooperate with me. So I guess I'm gonna have to try to go to my last one. Maybe that'll go. And if I can bring it to you. If I can't, then I'm just gonna go right straight to my closing argument. Stand by. Oh boy. Come on. Okay. My last two stories involving the woman who murdered a man and left a note in green highlighter, and the sentencing for Christopher Dontel, who was sentenced for his mistress's husband's murder. Neither one of them would pull up, so I can bring that information to you. I apologize for that, but I am gonna go ahead and wrap up with my closing argument. Now, remember what I brought you the story about the little boy who died in a hot car. His 2-year-old sibling survived, and mom took it upon herself to go to a medical spa for lip filler. Well, this is my closing argument on that. We've seen the PSAs, we've heard the warnings, we've mourned the children, and still another one. This isn't just about one mother in a spa. It's about a society that keeps letting this happen. Now we speak the name of Emilio Gutierrez, a 1-year-old boy who died with an internal temperature of 107 degrees, left in a hot car, while his mother, 20-year-old Maya Hernandez, allegedly underwent a cosmetic procedure. His 2-year-old brother, who survived with an internal temperature of 99 degrees, is now in protective custody. Just weeks ago, Justin Ross Harris walked free, years after leaving his son Cooper to die in a hot car. His conviction was overturned, but Cooper's death remains irreversible. And now, Emilio joins the list of children whose lives were stolen by negligence. Ladies and gentlemen, I forgot is no longer a valid excuse. It wasn't valid in 2014. It's not valid in 2025. And it's not valid not ever again. Because forgetting a child in a car, it's not just a lapse. It's a failure. It's a failure of responsibility, a failure of awareness, a failure of love. We've created these public service announcements to warn. We've told Sebastian Gardner's story recently. We've pleaded with parents, caregivers, and communities to remember. But memory alone isn't enough. We need systems. We need accountability. We need hearts that refuse to be distracted when a life is at stake. Let this case be the last another one. Let it be the moment we stop making excuses and start making change. I speak not from vain repetition. I speak not from repetition at all. I speak from righteous frustration. Because each child's death is a truth we refuse to face. And if, as my dear mother would say, the truth is the light, then let it expose negligence. Let it illuminate change, and let it shine the way to accountability. Every time I hear a case like this, I shed tears for the young victims. And the tears I shed today are not just for the latest victim, but they're for all the children whose names we learned too late, like a Cooper Harris, Christina Pengalangan, Emilio Gutierrez. I shed these tears for knowing their names too late. But I promise, as the last outlaw, with every PSA, every editorial, and every news story I report, I vow to fight for a world where I forgot is never spoken over a tiny casket again. This is advocacy reloaded. This is compassion reloaded. This is justice reloaded. This is Bethea'S Byte. And it's reloaded. I want to thank you all for joining me. Thank you to my replay gang. Thank you to all of you who sees it fit to stand up for justice for the victims. I'm Ernest Bethea, the last outlaw. I pray we can do this again next time. Hopefully back on my regularly scheduled time. But until then, you all know what to do. Bye.
Thank you all for joining me here at the Drama-Free True Crime Destination. Be sure to follow Bethea'S Byte Reloaded all over social media and get your coverage of true crime news with no gimmicks, no drama, and no BS. This is Bethea'S Byte, and it's reloaded.